May I please, my lord? I beg to mention item number 4. I'm on behalf of Morik Bagra Legal Aid Council. He could not attend today due to physical illness. So matter may be fixed after 3 weeks.
Just a minute.
And the consent has been taken from opposite party.
What's your good name?
My name is Tadar Bai.
The appeal was already admitted by order dated 7/11/2023. Registry has also prepared the paperwork. Office note discloses that notice have been duly served on the informant in presence of one witness. However, the informant has not appeared in the matter. Place this matter for hearing. At the hearing stage, the court, if so considers, may engage an amicus curiae for the informant.
Highly authorized.
Call one.
Item number 1.
My lord, it seems the petitioner, my lord, counsel is not there, my lord. In the last order, this honorable court directed that the state officer to take necessary action, my lord, and government counsel was asked to produce a report, my lord. By order dated 24/5, my lord.
It's very important. Para 10 onwards. Last direction was.
10 of. There are 10 onwards of.
Para 10 years.
Of
Court
which-
order.
of court. Of- Yes, yes. yes. The petitioner was also to file additional affidavit.
Yes.
What is your report?
No, sir, I'm yet to. Accept the report.
Madam, 2018, whether land has been vacated or not,
No, no, sir. This
whether land
order-
has been encroached or not. Whether the land it was allotted for the library has been encroached or not.
That has been ordered, it has been ordered on 24/5/24. By this honorable court to verify and also. In our affidavit, lots of verification is also there. Enforcement is there.
Whether the land was settled with the, is allotted for the library or not.
It is, okay. Library is also there.
It may be there. What is the total measurement of land that was allotted for the library?
Also, it is in our affidavit.
Please tell us from the your affidavit.
Also, it is.
See, this is one of the issues. In fact, you see, many of the houses around our old high court, where is presently construction is going on, all government quarters are occupation of private individuals. How can it be possible? If the government is doesn't have any power or nothing, is
Some
not
portion
effective.
has been enforced also. Here, 3,895 square meter. was,
If some portion has been enclosed, have you taken any steps for removing them, the eviction or to evict them? What action you have taken to evict them?
That action is not.
And you have allowed to continue over the, allow the encroachers to sit over it. If there is encroachment, what actions you have taken?
Also, matter was taken up also, and then there is a agreement between the,
What kind of agreement?
so that has been nullified by the.
What kind of agreement?
The-
What kind of encroachment and encroachers have? What kind of right and encroachers has? What kind of right? Tell us. Under which provision of law and encroachers have right? Forests are encroached. Government lands are encroached. How will you develop?
Excess area of operation is lost 158 square meter by the private respondent. This actual occupation is 300 square meter. Now, this occupation is 493. So its excess occupation is.
What was the land allotted for the library?
Library is also. In the order itself is there, that is order. So 3,895 is for me. This order for status order document 24/05/2021. Here, Lordship. All those have been taken care of and the chief assessor officer has been directed to Lordship. Issue notice again. Reopen the proceedings in respect of Lordship, the private respondent. The. Para 10 onwards, Lordship. Order for encroachment, minus presence. Lordship, in the last, honorable court order of the government advocate has been directed to produce the records of proceeding of the chief estate officer. The report of that. Sometime in the event of.
You want a library with beautiful garden so that the students, other people, retired people can read books, or you want that it should be covered by full of concrete jungle? You tell us. We are throwing this question to the bar.
One library.
Library is there, concrete library is there. But the library with the environment, have you ever been visited Nehru Memorial Library at Delhi? I'll request all the members of the bar, whenever they visit Delhi, they should go to Nehru Memorial Library. Newspapers which are not in the Northeast prior to independence are available in the Nehru Memorial Library. You will find all the research scholars studying in the gardens under the trees. An atmosphere was created there so that the readers, you go to Bangalore Library, City Central Library, you see the atmosphere there. People are reading, lying in the grounds, lying in the fields and studying there. You should have a facilities like that. If not for the people like us, at least for the future generations will be able to enjoy it. And bar is the main voice. Bar is the voice of public and nobody else. Look at the independent movement, all the lawyers. Bar should not keep silence in these matters. This relates to public. Sometimes there is a reason when it is a library, when it's a hospital, when it's a road. Everybody should rise above the politics. You don't have any information now. What about the chief estate officer Itanagar Capital Complex is doing? How will you get the report?
Lordship, this order has been set to motion in my affidavit, page 15, Lordship. If someone was issued to the private respondent and then finally they did a kind of settlement, so that has been nullified by the honorable court, that settlement. And then this, someone has been set in motion, Lordship. It has to be continued by the estate officer. Affidavit by respondent number 7, Lordship. 7. Respondent was 7. Page 15 note. Page 15. There is
Commissioner Papumpare was also subsequently impeded. It's respondent number 8.
Yes.
Probably name has not been inserted.
This day was, sir.
Okay, it's there. Okay. Okay.
In your file, it is not there.
No.
Okay.
There are settlement.
Because the court has observed. Okay. Considering the order dated 24/05/2024, passed earlier in this year, the chief state officer come state officer Itanagar Capital Complex Itanagar. No, you submitted before the court that it is now the power is vested with the Itanagar Capital Complex State Officer,
Yes. Yes. Not chief estate.
State Officer,
Estate officer.
instead of chief, State Officer, Itanagar Capital Complex Itanagar. On the next day, so I'll place the up-to-date status pertaining to the proceeding of what is the case number that was pending before him? It was reopened. After reopening, the same number will be there.
Yes.
Okay. Case number CEO oblique DAD oblique A, small, A to capital, double C double T dash 098 oblique 18 regarding encroachment of the land of the district library Naharlagun Itanagar. As the matter relates to encroachment of land allotted to district library Naharlagun Itanagar, Itanagar to bracket of diva. If at any stage the petitioner prays for withdrawal of this PIL, the court is of the view the same should not be allowed and it should be converted to a suo motu PIL. List on on 18th of July. MSJT learned government advocate shall inform the state officer such and such in that regard. A copy of this order be furnished to MLA for her necessary onward communication.
Man, Democrat's sword is hanging over my head also for last 6 years, man. Because
See, somebody is in the political supremo, that doesn't mean you have seen how many orders have been passed by the Honorable Apex Court. And that is why we said the bar should rise above. These are the things which are the public, not for only for us, for our future generations.
anyway, man, it's not as it is projected by the.
No, we are not on that side. right? But apparently there was an encroachment.
That only 5 square meters, Mal. That was
Whether it is 5 or 1.
no, Mal. That 5 square meters was a septic tank, Mal, constructed beyond the allot. That was Mal decided that it should be used by the library also, Mal, because they didn't
Things
have.
are not like this.
That's
It's
the
not proper.
Anyway,
Why should
yes.
already government has allotted you a land? Why should need to encroach?
Anyway,
Why do you need to encroach?
obligation.
Item number 2.
May it please your lordship.
You are appearing?
Your lordship,
Lordship,
I'm
Yes, yes, please submit.
Lordship, I am for the appellant, Lordship, as a legal aid counsel, Lordship.
For the appellant.
Appellant, Lordship, appellant.
now your lordship here, what has happened, your lordship? On the very first day, notice was issued to the victim informant. As your lordship, we are well aware that the notice has to go to the victim, not to the informant, if the victim and the informant are not the same party. So your lordship, what my humble prayer before your lordship is the notice may be issued to the victim family member, because the victim family member, as per the record, your lordship will find that the body of the victim was handed over to the parent for last rite. It is a case where a husband is alleged to have murdered his own wife, your lordship. It's in page number 14, your lordship.
Show us the provision
Your lord,
that notice should be issued to the victim.
your lordship, is a judicial pronouncement, your lordship. I would, yes, your lordship. Your lordship,
Family of the victim can, or the deceased can prefer an.
your lordship, first of
they are
all,
entitled for
yes, your lordship,
victim
first,
compensation.
yes, first of all, will come to the definition of the victim, your lordship.
That is not the issue
Yes, your
regarding
lordship.
issuance of notice to the victim or to the.
Yes, your lordship. That part, your lordship, as per your lordship, the judgment of the
What
Jagdi
is
Singh matter,
the,
your
what
lordship.
is the recent judgment?
Your lordship, on compliance of the judgment, your lordship. Our single bench is also, your lordship, has passed an order. I would like to refer the order of the single bench, your lordship, wherein your lordship implement of victim has not been made as mandatory, your lordship. However, the participatory right is still there, your lordship. And it has been recognized by the law that they are not
That is why
auxiliary
the-
or accessory to the public prosecutor, your lordship. They have independent right.
Listen.
Yes.
Very recently, an order has been passed by the Honorable Apex Court. Are you aware about that? Are you aware about that?
Recent order, your lordship, I am not
Yes.
aware regarding this.
Go through it. Go through it. There is no provision in the CRPC for issuance of the notice to the victim.
Is it
There is
because,
also no provision in the CRPC to issue notice to the informant, but the particular
But
judicial
your
pronouncement
lordship,
order
it's-
was passed.
yes, your lordship. And so far, your lordship, in the statute, your lordship will find in 173 subsection 2, your lordship, where it says the information regarding the action taken by the investigation authority must be given to the informant, your lordship.
Hmm.
So that statute recognize the
During-
information to,
During which period? That is during the investigation period.
yeah, this is there, your lordship. What
So
I'm,
that is why the criminal appeals are preferred by state. Why always it is state versus accused? Why?
yes, your lordship,
What is the reason? Since
your
you are
lordship,
tell us what is the reason it is state? Why not individual?
the state prosecute the, your lordship, the accused.
That's
The
what I
offense
mean.
are against the state, not with the individual, your lordship.
That is why.
Yes, your
That is
lordship.
why the question that raised before the earlier, it was discussed. So at best, since it is the informant who have brought to the notice for registering the case, that is why notice are issued, because otherwise the CRP show nothing in the after, when the appeal stage are there,
Yes,
it
your,
is not to be correct.
Yes,
But
so-
that is not the case in case of POCSO. In POCSO, it is very specifically provided in the act.
if
Right?
your lordship allow, then I would like to, your lordship, reflect some provisions. Why, your lordship? Because throughout the trial, your lordship, the victim has a right to be informed, your lordship, as so far as section 170 subsection 2 is concerned.
Tell us.
But and by the judicial pronouncement, the victim participatory right has been, your lordship, declared by the Honorable Supreme Court, your lordship. So now we are not on that the victim should be impleaded, but at least victim should be informed, so that, your lordship, the victim, if they would like to participate the appeal,
Show us any such order of the Honorable Apex Court or our High Court. Earlier, there was a order passed by His Lordship Justice B.D. Agarwal.
Your Lordship,
considering a
the-
judgment of the Honorable Apex Court.
Your Lordship may
But-
kindly, Your Lordship, Your Lordship, furnish the judgment of the Jagdish Singh matter, Your Lordship.
Yes, yes.
Where it says the victim has an unbridled participatory right from the stage of investigation till culmination of the revision or appeal, Your Lordship, it says, Your Lordship. Your Lordship will find in para
But
23,
this
Your
matter
Lordship.
has been very recently again taken up by the Honorable Apex Court. We go through that thing. It was there in the live law.
Your Lordship, only for my satisfaction, Your Lordship, paragraph 23. May I read, Your Lordship? A victim within the meaning of CRPC cannot be asked to await the commencement of trial for ascertaining his or her right to participate in the proceeding. She has legally vested right to be heard at every stage post occurrence of an offense. Such a victim has unbridled participatory right from the stage of investigation till the culmination of the proceeding in an appeal or revision, Your Lordship. Here it says, Your Lordship, till the culmination of appeal and revision, Your Lordship. And here in this judgment, it has been declared by the Honorable Supreme Court that the victim are not accessory or auxiliary to the public user. They have the independent, they can make an independent stand, Your Lordship. And which has been recognized, Your Lordship, in by our Honorable Court single bench judgment. They can, Your Lordship, participate separately, Your Lordship, without assisting the public prosecutor also.
There is a- But not in the- That's the definition.
It is PW two. It's fully, there's no problem with that, isn't it? And then the collections is a segment. He took care of the financing factor and so on. Is there their precedents for other certificates once you are present? So that may be there. So, no. Because this is clear. That is what right now. You are appearing as PP.
Yes, your lordship.
Come to the trial court judgment.
Yes, your lordship.
Indeed. Then para 11.
Yes, your lord. PW2.
Yes, can we read? We'll know what is there. You may not have read it, so read it.
Yes, your lordship.
So,
Or Jen Kadisu, your lordship.
so there is no legal error. And that's why 15 compensation has also not been paid.
Yes, your lord.
So in this matter, the question of issuing notice to the anyone from the side of the victim.
It
And
was
if you
your
go to
lordship.
the judgment of the
PW, as per the PW statement, your lordship,
PW was not the legal guardian. She was working in their house as a housemaid, household. She has to assist his household work.
yes, your lord.
His son also reposed, so it is very clear.
Dilip Kadiju was just an important, your lordship.
So that's why there is no legal error.
Yes, a legal hair is not there, no doubt, your lordship.
So the
But she has
definition,
been looked
you
after
go
by
to
the-
the definition. Go to the definition 2WA.
Yes, your lordship. As per your lordship, as per the statement, it seems like he was the lordship guardian, your lordship, earlier.
He was not a guardian. She was.
Since she was an orphan, your lordship.
That's right. From her childhood, she had grown up in that house.
He took care of Luki Jessibo since her parents were no more, your
So-
lordship.
Come to page number 7, para 15, you will know who is the informant.
Your Lordship,
Son of PW2. Read para 15,
page 7, Your Lordship.
para 15 of the judgment.
Okay.
He has clearly mentioned.
Dilip Kundu, yes, Your Lordship. Kundu is the present case. He deposed that the recipient, he know the accused since and his name is the accused was married to the together is the since the child used to have in the household. The child was married to accused person. She was like a family member. She after marriage the boy used to stay with him.
So they are not legal guardian.
Yes, Your Lordship.
Question of issuing any such notice. Info further, if you have talking about this judgment of the Honorable Apex Court of Jagjit Singh.
Yes, Your Lordship.
The brother has rightly pointed out, at least not the notice, that the information should be given. It's up to the victim whether to prefer an appeal or not. It's
Your
not
Lordship.
specified in the act, not like the special act. In even that judgment of justice, judgment of Jagjit Singh, Honorable Court at particular paragraph 24, 25, clearly laid down the provisions.
And Your Lordship, just for the reference, Your Lordship, that referring the judgment, Your Lordship. Now, Your Lordship, so far as the notice is concerned is clear. So far as Your
Notice
Lordship.
and information are two different parts.
Yes, Your Lordship. So now, Your
And
Lordship,
the
so
case in hand. Though the public prosecutor appearing for the state.
it is Your Lordship judgment, the order of the Rajasthan High Court Division Bench, Your Lordship. Just for the reference, Your Lordship.
It's okay. I think it has been mentioned in the judgment of the Honorable Single Judge. Brother Goswami's order also it is there.
Yes, in paragraph 2, Your
Brother
Lordship.
Goswami's judgment, it has been considered. I believe. Or that is a Delhi High Court judgment. Okay.
Yes, Salim, that the Delhi High Court judgment, and basing on that, Your Lordship, Deepak Nayak case was, or the guidelines was laid down in Deepak Nayak case, Your Lordship.
Placing the reliance in the judgment of the Honorable Supreme Court in the case of Jagjit Singh and others versus Ashish Mishra, alias Manu and another, reported in 20229 SCC 321. The learned public prosecutor submitted before the court that notice should go to the victim. Not only to the informant of the case. It is seen from the judgment of the trial court that the deceased lost her parents during her childhood. And from the evidence of the PW2 and PW it is clear that since her childhood, the deceased grown up in their family and held them in their household work and on attaining the marriageable age, got married to the accused. In view of the above, granting information / notice. Before that, right? Said PW2 or PW4 doesn't come under definition of 2WA of the CRPC. As such, sending information oblique notice to the victim as submitted by the learned public prosecutor doesn't arise in this case. This appeal was already admitted by order dated 7/11/2020. Place the matter for hearing in its usual course. It has been put at you, right? The paper book has also been prepared by the registry. List this matter for hearing in its usual course.
Obliged.
Obliged, sir.
Item number 3.
Lordship,
Yes.
Lordship, as per office note dated 12/6/24, service has completed to the informant,
Informant victim family, brother of the accused.
younger
And the
brother of
victim.
the accused appellant here.
Okay.
So this matter may be listed for hearing, Your Lordship.
Heard such and such for the appellate and such and such. Office note discloses that the notice on the informant been released out. The registry has also prepared the paper book. This appeal was already admitted by order dated 07/11/2023. List this matter for hearing in its usual course. List this matter for hearing in its usual. That's all.
Obliged.
Obliged.
Item number 5.
My lord, we have filed our affidavit, madam. Hmm.
Where is the office notes? Service report on the response number 3. Still evident. The petitioner is allowed to take steps on the response number 3 by dusty personnel service to be routed to the registry of this court. Such dusty personnel service shall be made on the response number 3 by serving a copy of this PIL along with the annexes appended thereto, obtaining its signature with date and seal in presence of one or more witnesses. Thereafter, petitioner shall file an affidavit towards completion of dusty personnel service on the response number 3. Such dusty personnel service on the response number 3 by the petitioner shall be made on or before 12th of July. List on 19th July.
My lord, meantime, if they file the reason letter to our affidavit, if they want to.
In the meanwhile, the concerned parties may file their rejoinder, affidavit in opposition of the rejoinder, as the case may be, on or before the next steps.
Obviously.
Item number 6.
Well, then item number 6, I'm sorry, I was supposed to file a status report with regard to the construction of the progress in the construction of the road. In fact, I was unofficially sent the status report also through WhatsApp, but I'm sorry, I misplaced that, my lord. So can this be fixed after the break, my lord?
Who is constructing the road?
My lord, now the PWD is PWD, my lord.
The report to be submitted by whom?
PWD, Executive Engineer PWD. Respondent number 11.
On the prayer of Mr. Anderson. On an additional advocate general. Some more time is allowed to him to submit the status report. The person to the order is 06052024. The executive engineer PWD Sayang Tajo division is coming district. Respond number 11. Through Mr. Anderson, additional advocate general of the state, shall submit the up-to-date status report relating to the construction of road, 81 kilometers, from Sepa to Santajo on the next date without fail. List on 18/07/2024.
Your
God bless.
Lordship, I may like to place a small prayer. Since it's been long, it's more than 15 years that road is not constructed. So there are in prayer number D, it's page number 48. There is we are praying for monitoring committee. So it will.
Let us see what is the status of the construction of the road, as been told by Mr. Ratan
Actually,
earlier for the court.
Your Lordship, as per the instruction of the petitioner, about 2 or 3 months before they are constructing, but now they stopped. So
Because
we are
of this,
worried.
maybe situation is, as you know, it's a rainy season. By
Yes.
constructing road, nothing will happen.
Yes, but it's more than 15 years, so people are suffering. So it's,
Definitely. Let the report come, then the court will act upon.
so maybe it may be the last chance given to them.
Status report, let it come before the court on 18th.
Item number 7.
Amicus appointed in this matter. Yes, legal aid was appointed. Who is that? Nikita, Miss Nikita Tangen. As per last order. Now, my lord, in this case, this appeal is directed against the impugn order dated 11/8/2023 passed by Special Judge Pashigat of the POSCO case. My lord. Here, what had happened was, my lord, the supplementary charge sheet was not even considered by the London Trial Court while framing the charge, and then proceeded with the trial under Section 5. My lord, will have a glance at page 12 for a moment of the paper book. This is answers to. You haven't received the paper book? Okay. Tentative view, my lord, will see this.
By order of this court dated 29/5/24, I was appointed as a legal aid counsel for the respondent, victim. A paper book has not been issued to me yet.
Last two paragraphs during, my lord. If page 12, my lord, will see. The entire trial is vitiated. And it is a case of predetermined conviction. And my lords are aware of the objective of the section 29 of the POSCO Act. There is a statutory presumptions with regards to the guilt of an accused. But to my understanding, these presumptions will not operate when the prosecution has failed to prove the foundational fact. And there is a judgment by our High Court, my lord, laid down by Lordship Quota. And that judgment is relied upon by various high courts today. That paragraph 71 of the judgment will speak for itself. The concept of, you know, that preponderance probability also will have to be appreciated in this manner. In any case, you know, the amicus has not been served with a copy. In any case, you know, page number 12 is the answer to this judgment, my lord. Even we need not to appreciate the evidence.
Not exhibited.
No, my lord, the supplementary charge sheet, page 12, my lord, will come. I'll demonstrate two paragraphs from here. When was this? My lord, first paragraph, my lord, will go through. Am I getting indulgence of my lord Partner to paragraph page 12 of the paper book? My lord will find the answer here. Page 12, my lord will come. That first paragraph we will not read, my lord, kind of the second, during, my lord, during further investigation, the blood sample, vaginal swab, uterine swab, nail cutting, blood sample, urine sample of the prosecutrix witness two, the mother, she has seen her daughter waiting the bed. But again, the alleged accused came on October of the same year. Where was the contradictions? Contradictions in page listing. I have brought this assessment. ये भी है तो ना, ये IA. ये वाला जजमेंट की कॉपी है, मोबाइल का लिखा तो अच्छा बेटर. Page 30 ना. हाँ नहीं थे. पोजिशनल है, ये रिपोजिशन है. हाँ वही तो 164 में है. कभी कभी बोलता है ना.
No. No.
I have received. Well, that's why I was.
paper book and praise procedure. The prayer is allowed. Furnish a copy of paper book to the learned legal counsel for the exponent number 2. This matter of.
But that's why I was praising for the IA. Suspension of the sentence. Prima facie, my lord, on-
Expectation, it will be heard. And in the last occasion also,
the problem is my lord Jagjit Singh. And thereafter Deepak Nayan judgment.
this is for hearing itself, hearing for final hearing, next day. Try to disposal.
Yes.
Just in,
Well, prima facie, there is a material for acute
The way-
setting aside, yes, my lord.
If you have any objection, just go through the, because recently you have been engaged.
Yes.
Go through, and if you want to file any objection. you
When
file
can
it.
I come back?
in fact, it is the duty of the state to file whenever there is an application for aid, you have to file your objection.
Yes.
Either you want or the, whatever, you have to file your affidavit. In any such matters or seeking suspension of the sentence, right?
My lord, yes.
Now, it's a matter relating to POCSO. The first right is of the victim. So, Ms. Dengan, you are required to file objection.
Hmm.
But if the appellant says that it is better to hear the appeal, then in that case, will not hear the IA, will go for the appeal. So, Mr. Tara, you are pressing on the IA.
Yes, my lord, I am.
In that case, both of you have to file your affidavits.
Or my lord, if it is, if the hearing can be taken up after 20th of July, then I
The
think I will
judgment
not.
was passed in August 2023. Hardly, not even a year.
No, prima facie, I can demonstrate this matter. This is not a case of
File your
conviction.
objection in the IA.
My
No,
lord,
instead of that, my lord, let us fix it on 20th, my lord.
subject to what my learned friend would say, but it would be
July.
better, more expeditious if the matter itself is heard.
No, we fix it on 23rd. My lord, 23rd of July.
Hmm,
23rd July
when is that?
for final disposal, my lord. In that case, I will not insist for the I.
Registry for the show. And the copy of a memo copy also.
Yes, he has to be furnished.
Yeah,
In the paper book.
okay. And show, furnish a copy of paper book to the current counsel to the exponent of 2. List is matter on
23rd for disposal,
23rd.
23rd
For hearing. For hearing.
for hearing, for hearing. No, no, complete, it will be better for me. Problem.
Problem.
Subject number 8.
Yes, Mr. Sekia. Well, this is against the judgment, my lord, dated 26/10/2021 at page 33. What's the matter about? My lord, the challenge in the writ petition was to the regularization of the present appellant and another, on the ground that by the regularization from the date on which it has been given effect, that may affect his seniority. However, by the impugned judgment of the Honorable Single Judge, the regularization itself has been set aside. And therefore, Your Lordship, if Your Lordship looks into the order dated 29/11/2025, while admitting the appeal, this also reflects in the said order. Now, the basic apprehension of the appellant, the writ petitioners, if Your Lordship looks into the writ petition, my lord, Mr. Secretary, just a minute, take your seat. Lord. We'll get back to you. That's- Yes, now what happened after this order of the Honorable Single Judge?
Single judgment, there is an order, my lord, dated 29/12/2021, whereby judgment of the Honorable Single Judge was stayed. That is the position, my lord. I am now serving as the, my lord, executive engineer of the department now. And
You
Honor-
appeared for the respondent number 6 and 7.
I had appeared for the respondent was 6 and 7. Now
Now they are the appellants.
now I am the appellant.
Where is the illegality in this order of the Single Judge?
My lord, the Honorable Single Judge has passed the order because of, my lord, absence of the record to show the cadre strength as on the date of my promotion. And in absence of the record, the court has considered the affidavit filed in another case, WPC number 543. That was filed by some of the junior engineers challenging the very advertisement under which the writ petitioners have been
Those
appointed.
were withdrawn.
No, that was that writ petition was dismissed, holding that the posts in which they are the advertisement at that time it was at the advertisement stage. Those are for the direct recruitment quota. My case is that I have been, my lord, appointed as a junior engineer. My lord,
No, that we have seen. The
Lodging.
thing is this, 20 persons were given ad hoc promotion
lodging.
to the AEC, right?
Lodging.
And there are no rules. So as per the, whatever was there, the
Rule was there.
rule was followed, 50%, 50%, right? For direct recruiting and
It was
for
their case.
promotion. Now, for the, since the benefit has to go to the promotees first,
Lodging.
so 31 posts or somewhere there, so
Lodging.
15 plus 1 was considered
Lodging.
for the promotees.
So,
So 16, but instead of that, they have promoted 20.
20.
So the next,
Lodging. This
when your promotion was due, you might have been were eligible at a certain point of time for your promotion.
Lodging.
But as per the post available under promotional quota,
Lodging.
when were that those posts were available for your promotion?
My
Which year?
in 2005. They are appointed in 2006.
That we have seen because they're
Lodging.
direct recruitees.
They're direct recruitees.
Now in 2005, the posts were available for you.
For
For
me,
your consideration for promotion, though were considered for promotion on an ad hoc basis.
no, that
otherwise-
was, no, my lord, yes, man, that was ad hoc basis.
So
And that,
otherwise.
that
no, because
vacancy
was an
that-
access, because they have appointed 20
according to them, my lord,
according to the state,
not
according to the
state,
department.
not
There is
exactly,
the
my lord.
department say that have
My
given
lord,
promotion of
it
20
is the
persons.
whole thing, my lord, has, that's what, my lord, now, my lord, by an additional affidavit after receipt of the RTI information, I have submitted the cadre strength as well as the persons in power. And so far as under that RTI also, my lord, it is clearly said, my lord, I have been promoted to the post, which is, it was under the promotional quota, and the person was further promoted to the post of executive engineer, Minal Bhattacharya. That document, your lordship, may kindly
No,
see.
some of them have promoted, no doubt. But thing is this, the
Mine
time-
was in the promotional quota.
the time when those persons were made ad hoc promotees and AEC, they have given such benefit to 20 persons, but posts were available for 16.
My lord, here what happened, my lord, initially it was the, my lord, PWD department. Then
Yes, bifurcated into two,
by fact, my lord, the power department was carved out in 2003.
right?
To make it functional, they have, my lord, absorbed the persons from the power department as well as they have promoted these junior engineers instead of going for direct recruitment, so that they need the experienced persons there. These persons, those who are absorbed, they are already from the direct recruitment quota. And some of these junior engineers from the, my lord, promotional quota. The person who was, my lord, Minal Bhattacharya, the document, your lordship, may kindly have a
See
look
this,
at that.
Can you, because at that time when it was bifurcated into two and power department was established,
Lordship.
for exigencies of service, these 20 persons were promoted as AEC in the power department. That were meant for, out of this clear, because only 30 posts were there for AEC. or say 31 posts are there for AEC. So if there are altogether 31 posts for AEC, then it is the stand of the government or the stand of the department is that 15 plus 1 is for the promotees from JEC to AE. And then the remaining posts are for the direct recruiters for the first category. Now, it is a fact that altogether 20 persons have been promoted to the post of AEC in the newly established power department, including you. But there was an excess.
I was subsequently in 2005 only, my lord. Otherwise, I was on ad hoc. My confirmation came only the person who was on the promotional quota was further promoted to the post of executive engineer. So my regularization is against the promotional quota, against which they don't have any claim. They cannot have any claim. And all these things happen because the record has could not be produced.
Yes, Mr. Ratan, you are appearing for the state. You just
One-
clarify.
One document, my lord, will kindly see, my lord. Only one document, my lord. At page
You are for the
120,
private parties.
as page
You are for the
179.
Direct recruits.
For 150.
Those direct recruits.
I'm only direct.
Okay.
My lord,
Page 176, you will also will see, my lord.
Yes.
The question number B. Officiating appointment of Ingi Angu, that is the present appellant, were made against regular vacancy. Yes, they were appointed against two of the above said regular vacant post of A against promotional quota. That was with the affidavit in opposition. Now in the additional affidavit I had filed after receipt of further information. At page 36, they have shown, my lord, who are the persons promoted on promotion. And the person in person direct recruitment at page 37.
Now in your additional affidavit, the answers are there at page 9, that is internal page 9, otherwise 295. Right? Page number, your additional affidavit.
Additional affidavit, my lord. I'm sorry, I was holding the other one, my lord. Page 21 is the, lord,
Internal page 8 is your the queries made by you. Otherwise 294. If you made the
page
contribution.
9, my lord.
Page 9 is the answer.
Answer, officiating promotion of Sri Ramyangu was made against Sri Minal Bhattacharya, who was promoted to the post of executive engineer when vacancy of post of AE fell under promotion quota.
So this reflects that all those 13 persons who were promoted. They were promoted against direct recruit quota. And later on,
He was against this Minal Bhattacharya was against a promotional quota. His father promoted to the executive engineer. So in vacancy that has arisen, I was appointed.
Yes, Mr. Ratan, what is the stand of this department?
Department also says he was under the promotional quota.
No.
The initial officiating promotion given to the this appellants, they were under the promotional quotas. Subsequently, it was regularized in the year 2012 with retrospective effect. My lord, I'll just show your lordship to clarify, my lord, at page 143. This was a writ petition filed in the year 2005, my lord.
Yes.
This is a judgment of that writ petition, my lord. My lord, there was a challenge made by the junior engineers. When the requisition was 10 posts of requisition was sent for direct recruitment to be recruited by direct recruitment. So this was challenged that 50% quota has to be maintained. It was they were claiming for promotional quota. This was about. May I read, my lord? It's a short judgment, my lord. In this writ petition, the petitioners have challenged the public advertisement dated so and so, inviting application for filling up of 10 posts of assistant engineer civil under the hydropower department. The present writ petition has been filed by the petitioners who are serving as junior engineers under the hydropower department. The basic of challenge of the advertisement is that in terms of the recruitment rule, namely the assistant engineer civil group B recruitment rules 1991, published by number so and so, dated 10 January 1991, which was subsequently modified by notification number so and so, dated 19 May 1999. As per service rules, 50% of the posts of assistant engineer available in the department should be filled up by way of promotion from amongst the working junior engineers in the department and rest 50% by way of direct recruitment. The grievance of the petitioner is that by order number so and so, dated 8 February 2005, 11 posts of assistant engineers were created for the department. The government, out of which 50% should have been earmarked towards promotional quota to be filled from the amongst the junior engineers working in the department, and not having been done, the interest of the petitioner has been adversely affected. Then an affidavit in opposition has been filed on behalf of the state respondent in order to appreciate the contention so and so. Here, internal paragraph 5, my lord, has been reflected. My lord, I'll just show the year-wise sanction, my lord. 1994, 4 posts, 1997, 8 posts, 2005, 11 posts created. Total, at that point of time, it was 31 posts. Total 31 posts. 16 was for the promotees and 15 was for the direct recruits. Here in the internal, if my lord will kindly see, as per recruitment rules of 31 posts will be 15 plus 1, 16, because normally first vacancy goes to the promotee and 15 posts will go to direct recruitment. In exigency of work, 20 posts of assistant engineer civils were vacant during 1997 has been filled up on officiating basis, but due to pending court cases, officiating ad hoc service could not be regularized. On withdrawal of the cases and on recommendation of Departmental Promotion Committee held on 23/7/2003, the officiating ad hoc services of the following persons have been regularized as details below. Here, 9 persons were. Now, 7 more posts are being regularized against promotional quota out of 15 posts against direct recruitment quota. Regularization of 10 posts have already been sent to Public Service Commission, but due to pending court cases, that is not eligible. Now, 7 more posts here, they have stated 7 more have to be filled up by way of promotion. my lord, accordingly, my lord, their contention was rejected because for direct recruitment, it was 15 and for promotees, it was 13. My lord. Now, this was the vacancy position at that point of time, 2005. It was 31 posts. Now, if my lord will come, because I believe the confusion has arisen because in the present writ petition, my lord, that was filed, my lord, in the affidavit filed in the writ petition. Affidavit of respondent number 2, my lord, will find at Annexure C, page 73. I'll take your lordship to para 10 at page 78 and continuation of the para 10, my lord, page 79. I'll just read 1, 2, 3, 8 lines from the bottom, my lord. It is pertinent to mention here that at present there are 48 numbers of sanctioned posts of assistant engineers in department. Now, this is of 2000, this affidavit is of 2013, my lord. After 2005, the post has been increased, my lord, to 48. So, total vacancy for the promotees should be 24 and for the direct recruits should be 24, my lord. 50-50 ratio. Now, therefore, my lord, what has to be seen, whether they fall in the year 2005 also, they were under the promotion quota, my lord, 50% promotion quota. Here, 20 DPC regularized 20 numbers, my lord.
Yes, Mr. Patin. If it is, there are posts available for promotion in the year 2005. And the petitioner, the present appellants were accordingly regularized, giving effect from 2005. Here, the original writ petitioners who are direct recruitees, how they are affected?
Yeah, now. What are disputing about the total scheme of the A.
No, because subsequent posts were created later. So at that point of time, 31.
Fine.
Hmm.
Now, as far as promoting 16 posts and direct recruiting is
15, 15.
15. Now this total is 31, no dispute. Now out of
16.
13,
Hmm.
they
Ah,
have
12.
appointed
Hmm.
20.
Hmm.
They have-
Hmm.
Now, while they have appointed, though the DPC was held in 2012, that is in 177
Hmm.
DPC,
Hmm.
they have given a regular promotion retrospectively with effect from 2005.
Hmm.
So my contention is that in 2005, there was no promotional quota. Promotional quota post was accounted. So, and all the private respondents 1 to 10 are the direct recruits. Direct recruits means from the day I join the service, from
You'll
the
be-
day I become a permanent.
Right.
So they affected me. While I was in AE, direct recruiting.
No, just.
This,
Huh.
their appellant, they were served at officiating basis. They were in officiating basis. How they can become the senior to me from the day of seniority, regarding seniority, and how I have appointed as A to A in 2006. He was served as officiating in 2012. DPC, how he has been given retrospective promotion that affecting my seniority. That is, and in 2007, when there was a graduation list of AE, this present appellant name were not there because he was not a member of the cadre. Since he was a member of the cadre, he cannot be senior to me. This is the main case who challenge in the petition. Now we have no dispute about the total district. They have already, it has already been exhausted. So these two persons have been promoted without ascertaining the total vacancy of the promotees.
Promotees.
That is the case, here in this case. Now, they are taking plea hearing here. Now, I'll tell you how they try to make confused in the court. They are telling mineral photocopy. Now, start with the page 76 of their lead appeals. Page 76.
Yes.
They have filed affidavit in opposition in against my petition. What was their plea? Their plea was that 2.14 vacant.
70, you are,
Because of the A.
Mr. Patin,
So,
Mr. Patin,
Satam,
you are placing the affidavit of the present appellants that have been filed in the writ petition or the affidavit of the state?
yes, no, not same.
No, no, affidavit of the,
Read petition.
no, no,
They are taking different plea.
okay.
They are taking different plea and Dialonso Satom and
Now, where is the affidavit of the present appellants in the writ petition?
76.
76 is the response number 2.
No, no,
74.
read it.
Readable page 76. It is part of the affidavit of opposition filed by the present appellant.
Para,
It is response.
yes. Para, kindly be seen, para 6.
That was shown by whom?
The affidavit filed by the present appellant, well,
Taro Mije.
no,
But present appellant.
present appellant.
In the writ
Page 7.
proceeding, this affidavit
the
was filed in the writ proceeding.
This
By the
Miller
present
Procedure
appellant.
is
Page
report.
number 76.
It starts from 73.
73 is the affidavit of the response number 2.
Response number 2. Lordship member. Yes.
Yeah, 76, 75. That the deponent denied the statement made in paragraph 4 and 5 of the writ petition and
This is
state that
government. Government.
That is government affidavit.
government affidavit.
Okay.
There were 20 official assistant engineer civil who were promoted in between 1997 to 1999 from the grade of experienced junior engineer civil in the exigencies of the experienced officer to make the newly bifurcated department of power functional. Out of the 20 assistant engineers, one Sri Dananso Tatam had expired and another Sri Vilka was terminated shortly. Against these two vacancies, response number 6 and 7, Sri Yani Amu and Oma Palo were given officiating promotion to the post of assistant engineer civil on 21/5/2005. Now, that is the
That is the stand of the department.
department. Now, again, there is the thing that Minal Bhattacharya was promoted as AE, and in the second post, his present affiliate was. But it was this very statement was very much silent while the proceeding was. Proceed.
I'll just make a clarification, madam. This is
We'll
regarding,
get back to you. We'll get back to you.
this is officiating promotion. And the regularization is against the Minal Bhattacharya post, that is a promotional post. This is officiating in the year 2005.
And total extent is already at 31. And exceeding has already been proved. It is established that promotional post has already been exceeded. When the promotional post has already been exceeded, without ascertaining the vacant position of the promotional post, without ascertaining it, these two persons were given promotion in excess above beyond the limited quota. That's why the present respondent from 1 to 10, they will challenge their promotion, their DPC in respect of the appellant, but it was not affected to the other. This is a gist of the case. Now, not take here and there. Well, yes, he may promote agents of such post, agents of such person, back and forth, but whether the post was available or not, promotional post was available or not, it was already been announced in 2005 by way of giving promotion of 17, 18 age, whereas in fact their post was, their quota was only 16. So how they can be, when they have already exhausted their post, how they can be regularized in a direct recruiting post? If any post was left, it was for the post of the direct recruiting.
Mr. Sakya, where is your officiating promotion?
Yeah, officiating promotion is
At page 65. The two hundred 65 okay.
Yes,
Yes, yes, no, I'll clarify, that 65 is the appointment as an adopt to the appellate. Now, that has been again complaint in page 93 also. Page 93 also.
93.
Then, here
Yes.
also.
Hmm.
No person's name has been mentioned. Now, how they have fabricated document? I'll show you the document, fabricated document. Now come to the additional affidavit. Come to the page 40. Page 40. How a single person will be appointed twice, thrice,
Additional affidavit.
for example, additional affidavit page 40. How they are fabricating, making the fourth document and submitting before the court. The governor of Odisha Kodak is pleased to order the promotion of Mineral Patasari A civil to the post of executive engineer civil on ad hoc basis in the scale pay of rupees 2,000 and farm plus center. The promotion is purely on ad hoc basis and will not bestow on him to any claim for regular appointment as such and such. Now, the ad hoc promotion may be terminated.
Additional affidavit,
Maybe
Mr. Patin, page number.
page 14. Now,
Filed by us.
file by.
Hmm.
Here they have taken the name of the mineral personality.
That's right.
Where the original appointment, they have not taken the name of mineral. They were appointed purely on the officiating. Now, whether a person can be appointed twice or thrice, it is very much clear that they were appointed on officiating. And because of that, in the in 2007, their name was not listed in the seniority list.
No, this is the promotional order of one Mrinal
The
Bachchan.
mineral was serving.
Hmm.
But in the appointment of their, their profession is that when the mineral was promoted, and in his place, I have this promoted. That is their fee. So but when this proceeding was done, they had taken that I had been promoted against the veterans of Galanso, Saita, and Liken Liba.
Two persons. One
Two
was
persons.
terminated, one expired.
Now one expired, one terminated. They have taken it. Now again in the read appeal, they have taken the plea that it was post vacated, but the mineral water charge for that I was promoted. That is their plea. So how they can take for single post, two vacant posts will come. So all these documents are fabricated.
Hmm.
4. Now, even if the matter is very simple, out of 31, how promoting will get the seat? And they have already been promoted. I am telling about the 2005. Had he been promoted in 2012, while the DPC was held, the matter would have been different. But here the matter is 2005. 2005, the total cadre of the A was 31. And out of 31, they
16.
actual 16 has already been appointed. Their quota is 16. So if any appointment is para to be met, it will be met through the direct recruitment quota. So there will not be, and more only to them. Without post, how he will be regularized and how he become senior to me. While I was appointed as regular A, next time he was on the ad hoc, he was on the opposite team. So that giving of retrospective promotion is service become illegal. First point. Second point, that there was no post of
Okay, kindly read the page 93, the appointment order of the appellant as assistant engineer, civil, 93.
the governor of Orissa Code is pleased to order the promotion of Sri Yami Angu J.E. Civil to the post of assistant engineer civil on officiating basis in the scale of pay rupees 8,000 to 13,500 per month plus other allowances as
As admission,
as admission
admissible under,
under rules from time to time in the interest of public service. The promotion is purely on officiating basis and will not bestow on him to claim for regular appointment as a civil. The ad hoc service rendered would not be count for the purpose of seniority in the grade and eligibility for promotion, confirmation etc. unless his promotion is regular by regular DPC in conformity with
provisions of recruitment rules.
recruitment.
Rules.
The
Officiating promotion.
officiating promotion may be terminated and appointment may be reverted to the original post of junior engineer civil at any time without assigning any reason thereof. On being promoted as assistant engineer civil, Yami Angu is posted as assistant engineer planning in the office of the superintendent engineer civil circuit. Now this is the case. I was appointed as regular in the year of 2006. Till to the DPC 2012, he was on ad hoc. So, seniority in the service career is the ornament for each individual who are serving in the department. So, how once I already established that I become a permanent member of the cadre since 2006, and His promotion has been on a DPC. His promotion was DPC was held in 2012. But given retrospective promotion, who is affect my seniority? This is the prejudice done by the DPC authority. Had he been promoted in 2008, I will not say anything because it do not affect my seniority. Without post, promotional post, he has been regularized. And thereafter, he has affected my seniority. This is the ground which we have challenged before the police court. Now, in this case, in the writ appeal, I have not seen any ground to interfere in the judgment which was given. Because the judgment is particularly based on the court document. Court document. The total strength was collected from the court document. It was already pronounced in 543 WPC 2000.
Mr. Patin, just one thing,
Now they cannot say that this judgment, which is there mentioned it in the court judgment, they cannot deny it. Apart from that, the government also made an affidavit before the judgment that they have clearly in the affidavit, they said it that only 31/4 of total interest, and out of 31 they have already filled up. Now remaining 4, which is vacant, that is 40. There is 40, that is recruiting. Now, very much wonderful. The same man who sworn affidavit in the court as government representative. This man is also here in the
The whole question, whether writ petition itself is maintainable.
yeah.
When he is not born in the cadre and the seniority list already prepared in 2010, where my name is above him, he has not challenged that seniority. That is final seniority list in the department.
your name figured in the provisional senior list of 2010.
2010.
Now,
That is
in-
made final.
Now, since your name figured in the provisional list of seniority list of 2010, above the writ petitioners, they filed a writ petition.
No, not for that. They, in 2012,
They were required,
we are regularized. Then they have challenged the writ petition.
Now this,
24/7,
this
2012.
seniority list of 2010, 31st of October 2010.
Done.
When it was finalized, when the final seniority list was published.
Well, that is the list. There already observation is there. If no objection is made, in that case, that will be treated as a final. 2000.
Now, in your additional affidavit,
Gotcha.
page 10, that is running page 296, internal page 10.
Gotcha.
This is a list of seniority list of assistant engineer civil. Now, in that list, you see, if you compare the affidavit of the department stand is from 1997 to 1999. 20 persons been promoted from junior engineer civil, right?
All are promoted.
All are promoted.
All are promoted.
So from 1997 to 1999. But in the judgment of the 1990, that other judgment which you have stated, it was delivered in 2006 in another writ petition. Up to 1997, there are only 20 posts.
1997, I was appointed as JE.
No, listen to us. The stand of the department is in 1994, 12 posts were created. In 1997, 8 posts were created. And in the year 2005, 11 posts were created.
Yes.
So, altogether 31 posts created. But the stand of the department is that from 97 to 1999, 20 posts to the post of assistant engineer civil have been promoted.
Yes.
So, if your stand is that you have been promoted, because the stand of the department is that you have been allowed to serve on office sitting basis against 2 persons.
2 different persons.
Who were appointed against direct recruitment quota, allowing them to office it against the post available for direct recruitment.
Maybe.
And both appellants or both the respondent number 6 and 7, they were allowed to serve against those 2 persons, one expired and one
On office setting.
on terminating, on a terminated. But those 2 persons were allowed to serve on a visiting basis against direct recruitment quota. That is the stand of the department. Now, if you have encroached upon direct recruitment quota, as for
But
the
those
stand
were
of the,
office seating, because as
No, no.
well as the affidavit also
Because-
discloses.
the persons against whom you have been allowed to officiate were initially allowed that's officiating promotion against direct recruitment quota. So since you have entered upon the post of direct recruitment, will you be able to get your seniority from the dates when you joined the service or the order was passed? These 2 orders were passed in the year
Here the
2005.
peculiar facts, therefore the detailed hearing would be necessary, because I have also included my submission, the writ petition itself is not maintainable. So far as the.
No doubt.
Gotcha.
No
So
doubt.
why
Have
I'm
joined the
saying.
service in
the-
2006 and you have been allowed an officiating promotion in the year 2005.
5.
But if you go with the stand of the department's affidavit, it is very clear that you've been allowed, though you were eligible in the year 2002 for your promotion, the posts were not available. And so let us assume in that way, and that was 2 persons, one expired,
Because
one
of
terminated.
departmental exigency.
But let us see in this way. 1 person expired, 1 person terminated.
Gotcha.
And these 2, A and B, were promoted on a visiting basis against direct recruitment quota. Since A and B no longer, who were promoted against direct recruitment quota, the respondent numbers 6 and 7 were allowed to hold their post on a visiting basis. That means what? You have been allotted to work against direct recruitment quota. That you cannot deny.
Yes.
You have changed your stand later on the basis of an RTI from the department. You are now saying that yes, against M. Bhattacharjee.
No, I'm not trying to change my
No,
stand.
no, no.
The
That
whole
was
thing has come
the
because the
affidavit.
government did not produce the record. My lord, that is the whole thing, my lord.
Did you at any point of time object? Did you at any point of time objected with regard to that during the writ petition, that you have been appointed against those two posts? Because the stand of the government is very clear. You have been
Lordship.
allotted against the direct recruitment
Lordship.
quota.
Lordship, my lord.
They have not said anything.
My lord, here, that's what I'm saying. My lord, the affidavit also government stands, my lord, says, as because it was carved out newly, so the persons from the available persons from the PW department, some of them have been absorbed and some of them have been promoted. Now, some these have been promoted, my lord.
No,
The
that is why
recruitment for the first time.
page 10, that
Lordship.
2000, October 2010 provisional seniority list of assistant engineer. That is very clear. The date of promotions are there.
My lord, page 10.
Hmm.
My lord, so far as
So if it is
Lordship,
20
can you
persons
see, my lord,
from
serial number
97
8, 9.
listen,
Serial
from
number 8,
97,
9,
that is
10.
that is the thing, from 97 to 99, 20 persons promoted to the post of AEC.
Yes.
So come to, from 97, you will see his name is SL Sudhuri, will come first. Now count
Lordship.
20.
Lordship. These are the total strength, madam. These are the total strength. Your lordship will find serial number, my lord, 8 to 13. They were executive engineer on deputation. Then serial number 3 to 13, they are also, my lord, direct equities in the original department. Because department has been bifurcated only in 1991.
No, your case will fall from SL Sudhuri. All are promoting.
My lord, as a cadre strength, my lord, the entire persons that has to be taken, my lord, as a whole, my lord. And the rules which was applicable at that time also speaks that the JEs, Lordship may kindly have a look, my lord, the JEs who have been promoted officiating basis, they will be regularized by way of, my lord, holding the DPC. That is in 1996. I'll just give precisely, my lord. Page 96, my lord. Page 96.
Yes. Page 96. Yes.
Because at that time, they don't have any rules. So they have adopted the rules that was applicable to the PWD. And the last your lordship will find here, your lordship will very interesting, my lord. The department will adopt the recruitment rules of so-and-so for filling up SC, JEC, AEC will in the department till framing of its own recruitment rules. There shall not be absorption of the SCEE, AEC bill permanently in the department who are on deputation from PWD department. 100% deputation at the level of SCCE to be continued until the present JE civil are senior enough to fill up the post reserved for promotion quota. No promotion shall be given to the AE civil so to SC during the deputation period. The JE civil who are appointed on ad hoc shall be regularized through DPC. The clear-cut policy, newly functional, the department has come with, they need the experience, not the direct recruitees at that stage. For the first time, the direct recruitment has come in the year 2006, and those are newly sanctioned. And why they have done it? Subsequently, they have created a further up to the 24 or something, so that the balance become equal, the direct recruitee and the promotion. The breakup they have given in the affidavit as well by the government also, my lord. These are not denied. So this is in peculiar circumstances. What is my fault, my lord? I have been appointed, promoted as per the rules, and then, my lord, continuously I have served. The cases that has been relied on of the case of Joshi is my lord, completely on a different, my lord, facts, because the judgment has to be understood in the context of the facts that was there, my lord. There the promotees were for the stopgap arrangement, clearly saying that till the direct equity fill up the post. And they were also not according to the rules.
Come to page 62.
Yes, sir.
Now, whether a department have placed the appointment orders of Daliamso Chitam and Lekis Libang.
I think it is not in the record, ma'am. So record will be necessary. Perhaps they have the records.
Mr. Ratan, whether those two persons were appointed against promotional quota or against direct recruitment.
My lord, that instruction I'll have to take.
That is the main issue.
Here, my lord, I'll just repeat that earlier page 146, my lord.
Hmm.
The judgment of 2005,
Hmm.
where 31 posts was at
Yes,
page 146, my lord.
yes, yes.
On withdrawal of the court cases and on recommendation of the Department Promotion Committee held on 23/7/2003, the officiating ad hoc services of the following persons have been regularized as detailed below. My lord will see Karam Permit, Taki Tating, all this.
Hmm.
And now 7 more posts are being regularized against promotional quota out of 15 posts against direct recruitment quota, so and so. Now these person's name, my lord will again come to page 69 of the impugned 68.
Hmm.
It says 7 more persons. Page 68 is the impugned DPC.
Hmm.
At serial number 12 to 18, my lord will find this person's name, my lord. Titi Goyang, Karom Perme, Taki Tatim, Abin Perme, Durik Kamduk, Gammo Kamki, Tapon Mibang. Their name still appears in this 2012 DPC also. My lord, how can the writ petitioner say that this is already exhausted? The promotion quota was already exhausted in the year 2005.
One further matter, my lord. This 10 posts newly created in 2005.
Okay, we'll come back at 2. Mr. Ratan. When the names of the appellants were incorporated in the gradation list as assistant engineer?
Gradation list, my lord. Gradation list as such.
For the first time?
Of 2007. 2007, there was a gradation list where direct recruitees were shown, but and the senior promotees
Page number 56.
56 years.
Whether at any point of time petitioners, rather than appellants, objected to that?
This was provisional seniority list, ma'am. In fact, my lord, at
In the
page,
seniority list of 2007, names of the appellants were not there.
not there. In 2000, page 95, my lord.
Yes. Right.
26 September 2007. Here.
Hmm.
Here, 18 persons were regularized, my lord, with retrospective effect.
Hmm.
Here, the names of these two appellants did not appear, my lord.
Hmm.
Now, accordingly, they have filed a writ petition at page 118.
Hmm.
Both the appellants.
Hmm.
And saying that the 80-20 reservation policy roster
Hmm.
between the APST and non-APST candidates,
Hmm.
that was not followed. Accordingly, the learned single bench had in the at page 134 as
Hmm.
direct on the basis of discussion made 134.
Hmm.
I find that the petitioner have been able to make out a case for setting aside and quashing the impugned order dated 26/9/2007 and direct the respondent authorities to rectify, modify the regularization promotion of 18 assistant engineers civil, including the private respondents. The impugned order dated so-and-so annexure is accordingly quashed and set aside, and the respondent authorities are directed to hold DPC and place the cases of the aforesaid 18 assistant engineers, including the private respondents, along with petitioners under the provisions of RR of 2005, 80-20 reservation policy and 100-point roster adopted by the government as a measure of rectification, modification of regularization promotion order dated 26/9/2007, preferably within a so-and-so period of 3 months from the date of this judgment. My lord, here the petitioners therefore were again directed, the appellants, my lord, present appellants were directed to be considered along with this.
Then what happened?
Now, after this only, my lord, it seems the DPC, impugned DPC, which has been after this order, my lord, at page 68. This was writ petition 53 of 2008. This was disposed on 11 6 to 2009. Thereafter, my lord, there was a order review application at page 136, dated 30/3/2011, page 136. There was a correction, my lord. Now, accordingly, after this review application, 30/3/2011, my lord, at page 68, my lord. May I read, my lord? A department promotional committee was held on 24/7/2012 under the chairmanship of Chief Secretary to the Government of Arunachal Pradesh in his office chamber for regularization of assistant engineer civil promoted on officiating basis during the year 97, 98, 2000 and 2005 in pursuant to the judgment and order of the Honorable Guwahati High Court dated 30/3/2011. My lord, this has been referred. Itanagar Permanent Bench, Naharlagan, in WPC number 53 of 2008, my lord. Constituted. This is the writ petition by which this honorable court had directed to consider the cases of the present writ appellants along with the private response there, along the seniors, my lord. Now, accordingly, this DPC was conducted and then the private respondents or the writ appellants have also been considered, my lord.
What is the length of service required for further promotion to the post of E from A? 5 or 10? 8?
From A to E, it is 5 years, I think.
5.
A recruitment rule for E is not available
Okay.
because we are here dealing with a recruitment rule of A's from J to A.
J to A.
Yes.
So from A to E, it's not available.
Not
So
available.
normally it is
5 years.
5.
5 years minimum.
Then at the time of, you see, in the year 2012, the direct recruit, which was recruited in the year 2006, they were eligible for further promotion to the post of E only.
Exactly.
Yes. If vacancy is there, they are eligible, further eligible.
So now if this superset
No, my lord. Here, in fact,
by,
the appellants are eligible from 2005 itself.
That is why.
Yes,
So then if it
And-
is given 2005 with retrospective effect from 2005, then they'll become senior.
senior.
So when they were already eligible for further promotion to the post of EE, they were not yet even in this cadre.
My lord,
Hey. So once it is considered, then they'll become a senior.
no, my lord, here, my lord will consider because of non-sitting of DPC of, for the promotees. Their right to be considered for promotion, that has been curtailed.
But at the time of their appointment, it was not yet considered. But since they are, they have already joined.
Yes,
now-
there is, that's why regular holding of DPC is required. Now, holding of DPC is not in the hands of the candidates, my lord. Now, if DPC is not conducted for years, those who are direct recruits, they will be getting the advantage, my lord. So retrospective regularization has to be done to maintain their seniority. Otherwise, because of non-sitting of DPC, all the promotees will be left, they will be placed below the direct recruits. Madam. Here is a case where the appellants, they became much more eligible in the year 2002 itself for being promoted as a AE. Thereafter, they were given officiating in the year 2005 only. They were eligible for promotion as AE since 2002 itself. Now, from the date of officiating promotion, that too in a regular vacancy, clear vacancy for the promotional quota, they have been retrospectively given. And my lord has seen DPC how they have once it was conducted in 2007, thereafter 2012, my lord. Now, apart from the present appellant, those in 1997, those who were eligible, they have been also given retrospective effect, my lord.
So that was in the year
Eh,
2007.
2007, that was set aside. 2012, subsequently, the DPC was
And in
held.
2007, the case of the appellant were not considered.
Yes, my lord.
So,
So they filed a writ appeal,
yes.
or writ petition.
Yes, that is right. So, when they were appointed in the year 2006, the respondent,
Yes,
and at that time, the appellant were not yet AE,
no, ma'am.
so they were junior. And subsequently, a DPC held in the year 2007.
Seven,
In the 2007 also, the case of the appellant was not considered.
not considered.
So now you see, thereafter, the respondent has probably the legitimate expectation that in the year 2007, we were otherwise senior in the cadre of A. And in the 2007 also, their case has not been considered. So,
My lord,
Hmm.
they cannot have a legitimate expectation because of
So-
the non-conduct of the DPC. What is that?
This is it's not on the wrong on the part of the respondent also,
Yes,
non-conduct.
yes.
Hmm.
The
But
direct
then-
recruits
But then,
cannot.
but then after 7 years of serving as AE, as a senior to the appellant, then suddenly,
My lord,
It is-
not only the appellants, if my lord will see, the impugned DPC at page 68.
for 20%.
20%, my lord.
Yes,
Right
because
from,
earlier up to 18%.
yes, my lord.
Now,
Right from
now,
1997.
on the direction of the court only, this was conducted, including these 2%, 19 and 20.
Yes, my lord.
Hmm.
Now, non-conduct of DPC,
Hmm.
right from 1997. Now, in 1997, the direct recruit is where either they had qualified, they have obtained the degrees or not. There is also 1997, they were eligible, these persons.
No,
Serial number 1.
Hmm.
Serial number 1 to all these persons.
no,
Till
I think we are concerned with 19 and 20. 19.
19 and 20, my lord.
Yes.
The same proposition of law applies. These persons from 97 also, they were denied regular promotion because of non-holding of DPC. Now, when persons from, since they were eligible since 1997 also, they were not given regularization. And only in the year 2012, they are being given with retrospective effect. Can that direct recruitees of 2006 even claim that we have a legitimate expectation that 1997
No, that-
officiating
their
is,
appointment was 1997. Appointment as a sitting.
yes, promotion, date of promotion, regularization. My lord will say 24/6, serial number 1, 24/6, 1997. They were
So no,
promoted on officiating
no,
basis.
no, that is different because their appointment was 1981.
Yes,
That is different.
yes.
But we are talking about this 19, whose appointment
Yes.
itself was on 1997 only
1997
as a
as a
ad hoc.
ad hoc.
Hmm. No, not direct recruited, it's ad hoc.
Yes,
No, 97, my appointment was direct recruitment.
direct recruitment,
I was the first person in the direct recruitment of
As a junior
1997.
engineer.
junior engineer.
That is for junior engineer. I am the first person. I am also
Okay,
Bachelor of Engineering.
so as officiating as an assistant engineer only,
That is in 2005.
2005.
2005.
97,
I became qualified in 2002. 2005, I have been given the ad hoc promotion.
he is a appellants are BE civil, my lord.
Yes.
They were appointed on the direct recruitment as JE in 1997. As per the RR, degree holders were eligible for further promotion in the year 2000, after 5 years, 2002, my lord. Now, instead of they becoming eligible, in spite of becoming eligible in the year 2002, they were given promotion only in the year
So,
2005.
but there was a post lying vacant
Yes,
and against the said post,
they have been
they were appointed as on officiating basis.
officiating basis, subject to regularization by the DPC.
DPC
Yes,
in the appointment itself.
itself. Now the DPC should have regularized. Now DPC has conducted, for one or the other reason, DPC could not be conducted. Now in the year only, lately in the year 2000, after 7 years, DPC has considered giving them their dues from 2005. Now,
Yes, yes. Although they were under officiating, but then they were senior.
yes, my lord, senior, they were
Senior
eligible
in the
for
post of, in the
promotion
post of AE.
in 2002 itself.
Eligibility since 2002,
2,
after completion of 5 years.
5 years.
Hmm.
Now, after 4 years, direct recruitees come. They become eligible in the year 2002 itself.
So
Given-
only the thing is that their DPC could have considered their case in the year 2007 itself.
Yes, my lord.
Having not considered in the year 2007, they filed this.
DPC could have been
petition.
considered in the year 2006 itself also.
Yes.
Every year, he had the DPC.
They
being
had the
conducted.
DPC hall.
Then,
Hmm.
without any obstruction, without any litigation, had the DPC been conducted in the year 2000, end of 2005 itself also, they could have regularized from the date of officiating appointment.
Right.
Now, 2006, there are direct recruitees come. Had the DPC conducted
So
in the
year
month of
2006, when the direct recruit was appointed, they
Uh,
were already holding the
yes, they were already
holding
holding the post of,
the post of AE, of course,
yes,
of course, officiating.
yes.
But they were senior only.
They were, yes, they were already senior.
Hmm.
The appellants were already senior. They were already holding the post of A. 2005, 2006, the direct recruitees came. Had, my lord, I'll just clarify, had the DPC been conducted in the month of December 2005,
Yes.
they would have been regularized from 2005 itself, my lord. Now, the question of the direct recruitees being senior to them would not have arisen. Now, because the DPC could not be conducted, how can they be made to suffer, madam? Their rights can be curtailed.
Right.
Therefore, the legitimate expectation of the direct recruitees.
So the only, now the question is that exceeded the post.
Yes,
Hmm.
if they say exceeded the post, then I believe if from the impugn order, ma'am,
Hmm.
at page 68,
Hmm.
the very contention of these two appellants
Hmm.
in their writ petition, earlier writ petition, was that 80-20 ratio was not followed. The reservation policy was not followed. Promotion in the year 2007. That reservation policy, therefore, the court has set it aside, my lord, since it was not followed by maintaining 80-20 ratio. 80 is for APST and 20 is for non-APST.
In the promotion also.
Promotion, my lord.
Okay.
So, review DPC was directed to be conducted in to consider even the present appellant's case. Now, in the review DPC, they have considered the earlier also and along with the appellants, my lord. Now, if 80-20, if what I say, if this also exceeds, if they say now the present post is 48, 24-24. If we go back to the year 2005, 16-15, out of 16, if regularization should have been made on 2005, then out of 16, how many will come? How many of the APST officers will come in the within the 16 and how many APSTs? In that event, pilot, I believe only the last part of, if we deduct 4 out of 4 from the list, that will be the Hari Singh, BK Roy, Jain Tripathi, and Shiva Das are serial number 7 to 10 of the impugn recommendation. In this case also, if they if their claim, the direct recruit claim is that they have exceeded, then also if 80-20 ratio is maintained, then these are the persons from serial number 7 to 10 who has to be challenged, my lord. In any case under 80-20 ratio, the present appellants comes. In fact, their challenge is made that excess, but
Is with regards to the inclusion of the 7 to 10. If the challenge had the challenge made,
yes,
then
they should have challenged the inclusion of 7 to 10. Because in any manner, these present appellants, they would come under the 80-20 ratio.
okay, if they want to claim the 50-50 also.
Yes.
Hmm.
By saying that these have been appointed in excess so as to retain their seniority, the appellants cannot be made to suffer, my lord. If it is in excess, then the excess of the 80-20 ratio has to go. In any case, those persons can rank junior to them. They have not been made a party, my lord. right from serial number 1 to 10, my lord. 1 to 10, my lord. All non-ST candidates, my lord.
Mr. Ratan, additional AG, kindly come to 118 page.
Yes, madam.
So. Advocate for the petitioner.
Yes, my lord, but I don't remember, my lord, because this was when I was assisting Peter, my lord.
Even in some cases,
In that event, my lord, otherwise I don't remember. I don't know them also.
That is why that
Of course, my lord. I don't remember this also.
even for the appellant. Even for the appellant as a.
Yes.
Counsel.
In that event,
So, propriety demands that
yes.
you should abstain from.
Otherwise, I don't know them.
You
also.
okay, please. The petition is.
In that event, my lord, can this be listed after? Because if
And if you didn't find that, page 143.
In fact, brother's name is also there.
144. 144.
144.
144. My name is also.
But not for the any party here.
Oh, yes, my lord. Yes, my lord.
But Mr. Ratan and Mr. Saikia, this affidavit shown by now which also you have been relied upon. Please come to page number 146. Mr. Patil, page number 146. Now, please come to the last two paragraphs. There is a paragraph as per recruitment rule, page 146. This is an affidavit, part of the affidavit of the state government. In the other case. Okay, where brother was a party to the petitioner. But anyway, that is not the issue here. So if you come to page number 146, Mr. Saikia, kindly read that paragraph. As per recruitment rules, it's after para 5 down below.
Yes, yes, got it.
After that, chart of 31 posts.
With regard to this one made in para 3, informant.
No, as per recruitment rule.
As per related existing recruitment rule.
No, not
No.
that. Page 146,
As per recruitment rule, 50% for
31,
31 for will be.
15 plus 1.
15 plus 1, 16. Because normally first vacancy goes to the promotion and 15 posts will go to direct discipline. In addition to the work, 20 posts of assistant engineer, civil, which were vacant during 1997 has been filled up for operating the system. But due to pending post, the executive adult service could not be regularized. Or enroll of the court cases and all recommendation of the Department of Promotion Committee held 23/7/2022. The officiating job services of the following persons have been regularized as detailed.
So these are the 9 persons whose services has been regularized in the July 2003. That, can you look at this para on withdrawal of court cases and on recommendation of Departmental Promotion Committee held on such and such July 2003. The officiating ad hoc services of the following persons have been regularized as detailed below. So these are the 9 persons. Now the next line. Next line is important. Now, seven
More posts are being regularized against promotion quota.
9 plus
Out of 50,
9 plus 7, 16. Quota is over. Mr. Sakia, now please come to page number 179. This is of 2012. Page 179.
Yes.
This is 2012. Yes. Your decision of regularization of service. How many promotees? Start from 1. All are promotees. Cannot go beyond 16.
Yes.
And the name of the applicant figures at serial number 18. At any cost, it cannot go beyond 16.
That is the crux of the case.
Whatever the roster, it cannot be, it will be for promotion quota will be different, for direct recruitment will be different. It has to be, cannot be tagged together, 40% roster or 80-20 roster. So that clearly indicates that it is already 16 posts. They have your position at serial number 18.
I have to look into.
And what brother has pointed out, that the direct recruiters were of the 2. And for this reason, in that region, in 2012, there was a DPC. By that time, these writ petitioners, now the respondents hearing, have already become eligible for their promotion to the next higher post. Now at related stage in the year 2012.
No,
they are
but
asked to be-
this DPC of 2012, that had initiated way back in 2007, where our names were not included. So we have challenged in the writ petition.
That's
So
why we are
2007 DPC minutes and the order has been set aside by the court and directly recast it.
Quota is 16, right? Quota is 16. Page 146 says 9 persons regularized.
That's it.
Fine. Then the same page says another 7 persons name are there recommended for promotional quota, regularization of promotional quota. Least at page 179. So the person's already there in the promotional quota. And in that promotional quota post, you are at serial number 18. And you cannot go beyond 16.
See, what if,
See,
well, not
9
only
plus
this,
7.
but the policy of the government, you'll also can see, it has to be looked to the, from that angle also, my lord. In supporting to that, my lord, I'll come to the decision of the court, my lord. The newly bifurcated, my lord, the department, they did not have any at that time.
That's
So
true.
therefore, they have been inducted from, my lord, the, my lord, from the erstwhile, my lord, PWD officials. So therefore, to, my lord, come to the quota ratio for newly created 10 posts has been totally earmarked for the direct equity. This 50% promotion and direct equity has to be followed by following this particular of 31. Then 50% of the direct equipment 10. 5 posts ought to have been gone for the J's for promotion.
That was challenged.
No,
right?
that was not that was
So-
challenged, and the court held that this is for direct equipment.
That is not under challenge. That order of the learned single judge is not
No,
under
the policy what I'm trying to, my lord, impress upon, my lord. So not only these 10, subsequently many others.
He was holding on beyond 16. Beyond 16. Mr. Sakya, what brother is pointing out as the proprietary demands and since under the consideration that okay. Now next available DB is brother Ete and brother. So both the brothers, now brother is also saying and I'm also tangled with somehow in one of the matter. So connected case, although it is not connected, but if division bench with brother Ete, it may not be possible for brother Ete to take up this case, because as you have seen at page 137. Brother Ete was leading Mr. Ratan. So maybe possible sometimes in a division bench, not having brother Ete. Yes.
Even I did not notice, nor he has
No,
noticed.
no, these things, normally we don't go for all this, no, suddenly it's cropped up. The proprietary demands, how Mr. Ratan will remember what's happened so many years back.
In
It is not
fact,
possible for him to.
recently only, my learned friend, he gave me this brief also.
No, no, no. Otherwise,
I also,
we're not saying, but thing is this proprietary demands, it should not be.
No, understood, no.
That is to be very fair. We're sitting for that purpose only. Mr. Patil, as we have noticed, in the case that, 118, page number 118. 118. Appellant is the petitioner number 1 here. Right? So even brother Ete will not able to take up because he was the leading counsel. And Mr. Ratan has a good purpose now, it's not possible. So we should have a bench without brother Ete and brother now. Brother Habung is saying that since I was also a counsel in the other case, page 143. 143. 43, he is no way connected. Page 143 is another repetition 543. He has come to page number 144. 144.
Yeah.
You'll see the counsel for the petitioners, brothers name figures therein. 144 down below,
Yes,
right?
yes.
So we should have a bench not of having brother Ete and brother Habung is refusing to take up the matter because of his name somewhere connected to another petition. It's not related to this petition, but we'll have it sometimes in the week. Which week will it be? Stay here for 2 weeks. no? In my drawer, second drawer, the roster is there. Second drawer, get the roster. We'll fix in a date where brothers are not available. We'll get the roster. Because Mr. Sekia, after vacation, brother will be available and brother Eti will also available.
Yes,
So, so only after when they are
Any
not
next available bench,
so
madam?
next available bench. Ah. He'll be up to July in. Let us see the roster. Let us see the roster. We commencing from 15 and we commencing from 22nd, brother Eti. So in the first week of August. Because in this 1 week, brother Eti and.
Oh, my lord, fix in any available bench so that lordships and we'll mention whenever the bench.
No, just will give you the date also because considering that there is a stay order, we have fixed it today, but we did not look in all these things.
My lord, 22nd to 26th of July.
That
Yeah.
brother Ete is leading, no?
No, my lord, here Justice Wangkung and that bench is there.
The last week, 22nd.
No, my 22nd to 26th for 1 week.
No, just a minute, let us. Let the roster. We'll not write anything, we'll just. Yes, will be fixed in a week commencing from a particular date, okay? Thank you. Mr. Saikia, week commencing from 22nd or week commencing from 29th, give us a date, or not 29th. Week commencing from 22nd or week commencing, that is only 1 week you have. Only 1 week, 22nd to 26th.
Of first week
Rest-
of August or something.
Not possible.
Not possible. In that case, my lord,
Only week is available for you is 22nd to 26th.
22nd, let it be on 22nd.
So we fix it on 23rd.
23rd, my lord, I have some fixed matter.
No, otherwise this bench will not be available.
No, on 22nd, my lord.
22nd is Monday.
22nd, I will be able to do it. Because on 21st, I'm having to accept you.
22nd, 23rd is Tuesday, so better to have a hearing day. It will take some time.
Interest is fixed, my lord, that is.
You have to manage sometimes. Otherwise, it will not be possible. Either brother Ete or either brother Habung will be available. We fix it on 23, you arrange,
23rd, let it.
because it might take some time. 23rd, okay? As agreed by the parties. and considered by us. List this matter on for hearing on 23/07/2024. Publish.
Lordship, this matter has listed for supplementary hearing, but as per the office note dated 12/6/24, service has not completed to the informant.
Your Lordship, in this
That has been
matter,
written.
the service report has written because the family has, the informant has died and the family has shifted out of the state, Your Lordship. In that case, Your Lordship may appoint any legal aid counsel.
This is a POCSO matter, Your Lordship.
No, that's the informant was only a JREF employee,
Yes.
nothing to do.
Your Lordship, in this matter, this is a POCSO matter, Your Lordship. So informant was the father of the minor. Your Lordship.
That not the informant, the victim.
Yes.
Family of the victim should be informed.
Yes, Your Lordship. The family has.
Just let us see just a part of it.
Lordship may peruse office note dated 12/6/24.
Just a minute. Trial court record. Trial court record. Just a minute. Has to be there. Hmm. Do you have a list of amicus curiae or legal aid counsel? No, you have to first of all. You should be present because.
Hardness. Teaching and something. Miss and Andrew. Legal counsel for the applicant. In view of that, please note that the 12/6/2024. Secretary for the High Court Legal Services Committee. Therefore, on legal counsel to represent the victim.
That's one number two, I think. So.
This is matter after. Previous.
Please. Obliged.
Have you received the copy?
No, I have received a copy, the paper book.
That's fine. That was on the council.
And start copy of the property.
Obliged.
Your Lordship, even the service in this matter has been completed, Your Lordship. However, for the appellant, since this is a jail appeal, Your Lordship can appoint an amicus curiae to assist the court, Your Lordship.
Jail appeal.
Yes, Your Lordship.
Appeal has been admitted.
Yes, Your Lordship. In fact, notice was also issued, which has been completed.
Where is the note of the district judge Bundila?
Your Lordship.
The district judge notice is not given. No, because for the appeal. Only this. That's good. It's okay. People who hasn't prepared. Just maybe mention that.
Yes, for the appellant, Your Lordship.
Okay, part Miss Jenny, learn additional PP for the state of AP staff. The office note dated 12/6/24 reflects that the service is completed. However, no one appears on behalf of the applicant staff.
No, no one for the informant.
Informant. The event for, no, even for the applicant also.
No, this is from the
Jail appeal one, okay, no one appears on behalf of the informant staff. Say. Appointed. No. Okay. Okay. Mr. Menki Boje.
For the
From the he is appointed as a Marcus Fury for the appellant staff. He appellant, and then and they are again for the register 3 High Court Legal Services Committee shall appoint one legal aid counsel for the informant, respondent number 2 staff. The both the counsel, amicus curiae for the appellant and the legal aid counsel for the respondent number 2 shall be furnished with the paper book. Okay. Okay, let the name of the appellant, amicus, as well as the legal aid counsel for the respondent number 2 be reflected in the course list. Staff. List is matter after 3 weeks. Okay. Yes.
A positive time. It has been left out for 3 times.
When do you want?
Maybe on 26 tomorrow. If not tomorrow, then 28, my lord.
Okay, tomorrow.
Tomorrow. God bless you. God bless you.
May I please, madam? Item 23, I have received Paravise comments will file affidavit position. So this matter may be fixed just after break.
When you're able to file your affidavit?
Within a week, we'll file.
You are appearing for?
RWD, standing for.
No, respondent number?
Respondent 1. I'll have to. Status.
Okay. On the pair of such and such. He is allowed to file affidavit. Or no before.
My name is not reflected there.
Okay, doesn't matter. Just give us the respondent, that will just.
Okay.
17th. Or make it 18th July. Huh? List on 23rd July. Yes.
May I, Lordship, I would like to mention item number 19, Lordship.
No.
19 lordship, this matter may be lordship allowed to withdraw lordship as lordship petitioner's lordship have no more lordship. Item number 19 lordship.
What is your prayer?
Lordship allowed to withdraw lordship.
Want to withdraw?
Yes, lordship.
Is your name reflected in the cause list?
Yes, lordship.
Okay.
G Bam lordship. I informed the other side lordship.
Item 19.
Yes, lordship.
On instruction of the petitioner.
Lordship.
Sri Podo Jomo. His counsel. Mr. Such and such. Is not pressing this petition. Accordingly, petition stand dismissed. Being not pressed. Yes.
Lordship, I would like to mention item number 26, Your Lordship.
Mhm.
I've taken the consent of the petitioner, Your Lordship. May kindly take up this matter after
Put into
vacation.
time with- Yes, Mr.
After
Sharma.
vacation.
Well, I beg to mention item number 10.
Hmm.
Well, I have taken,
Hearing, we don't think so, we're able to take.
No.
Time may not permit us.
this matter may be listed on 29th of July. I have taken consent of the other side. Other side there is no objection.
29th of July,
29th of July.
on the prayer of Mr. A. Sharma, London Senior Counsel. Matter be listed for admission on 29th July. But, okay, let us, yes.
My lord. Item number 12, my lord, we are seeking some accommodation. Can this be listed after break, my lord?
For the petitioner,
My lord.
on the prayer of the council for the petitioner, list after 4 weeks on a date to be fixed by the list.
Obliged, my lord.
Yes,
May I please, my lord? My lord, I beg to mention item number 13.
1-3.
1-3.
What's your prayer? Yes,
Senior counsel is out of station.
adjourn for 4 weeks. On the prayer of the council for the petition. Okay,
Obliged, my lord.
yes,
I'm appearing on behalf of the Kaushik in this matter, 13 for petitioner.
on behalf
We
of
have-
parties.
We have
Don't
taken the
make it for
consent from
parties.
other party.
Don't make it petitioner, make it for the parties. Okay.
Obliged.
May I please, my lord? I beg to mention item number 8.
Hmm.
Matter may be post after puja break or vacation. The union is yet to file their affidavit. I am for the petitioner, my lord.
After 4 weeks. No need to fix it.
Highly obliged.
Your Honor, I beg to mention item number 1. I'm appearing for the respondent number 3 to 12.
Hmm.
And
What's the
also,
matter about? This is a 2017 matter. Let the matter reach. Wait for some time. Yes, next.
I beg to mention item number 9.
Yes, what's the matter about? You are appearing for whom?
For the petitioner. With the consent from the other side, other parties.
After 4 weeks.
Then matter may be listed after 3 weeks.
Okay. It will come after 4 weeks.
Much obliged.
Your Lordship, I beg to mention item number 7. I'm on behalf of the conducting council, Your Lordship. So the opposition have already filed an affidavit, so Your Lordship, we are to file the affidavit in reply. So the respondent hand.
On the prayer of the petitioner, he is allowed to. Guru Nangiva, I don't know, he or she. It should be he. Allowed to file a rejoinder. on or before 22nd, list on 30th.
Much
Yes.
pleasure. Lordship, I beg to mention item 28 and 29.
Item?
28 and 29.
Yes.
The maternity.
We don't think so. We'll reach hearing.
Yes, it is supplementary.
That's true. We don't think so. We'll reach hearing.
Yes, well, that's why all the party consented the maternity
Fine,
on
doesn't-
8th of August, Your Lordship.
We are not fixing the matter. It will come in the first week of August. Okay?
And Your Lordship,
Yes. We are not giving any fixed date at this moment.
after vacation, Your Lordship.
Definitely.
And Your Lordship, item number 5.
5,
Yes. Maybe
you are appearing for whom?
petitioner, Your Lordship. On Friday, Your Lordship. Passover for Friday, 28th.
Not for Friday. It will come after vacation. What is the matter about?
This is Your Lordship, okay, acquisition matter. Acquisition, land acquisition.
Land acquisition matter. What happened?
As there is some portion of land, I am claiming that part. All the procedure has been done by the respondent.
Hmm.
So I am claiming only that and that particular area, my land is also included.
It has not been taken over, it has been taken over.
No, yet to take into.
Not yet been taken.
Yes,
Left out from acquisition or what?
yes. There is some particular area where there is certain land. I am claiming that and that part also my land is included. They are denied that. No.
They doesn't need that. Can you compel somebody to acquire your land?
Your Lordship, I am challenging here in item number 5, the impugn order passed by the Deputy Commissioner, West Siang District.
They may not acquire your land. Will you be able to compel the authorities to acquire your land?
Your Lordship, I have filed an objection under Land Acquisition Act. During the pendency of that objection, the Deputy Commissioner has passed the impugn order. I am challenging only here the.
Wait for some time. Wait for some time. Let us go to the matter and I will consider your prayer. Yes.
Oblige with.
May I please, Your Lordship? Your Lordship, I beg to mention item number 14 on behalf of learned counsel E. Parme. Counsel for the petitioner, Your Lordship.
What is the matter about? Why it has been listed for orders today?
Your Lordship, I have no idea, Your Lordship. As she is telephonically informed. Your Lordship, there is a letter of absence from her also.
Service of notice is complete on the respondents. Respondents in the education department have already filed their affidavit. Place this matter for admission in the week commencing from 29 July.
Your Lordship, in that case,
In
Your
the
Lordship,
meanwhile, the petitioner may in the in the meanwhile, the petitioner may on or before 25/07/2024 file rejoinder to the affidavit of the respondents number 1 and 2, if any.
much obliged.
Yes.
Item number 9, there is an entry that may be continued.
Have you informed the other side?
No, I'm from the petitioner.
Have you informed the other side while
Yes,
taking?
yes, sir. Yes, madam.
If there is interim order, this item number 9, we fixed it. We commencing from, make it on 25th of July. Till then, interim order first release. Okay, yes.
May I, Lordship, I beg to mention item number 20. On behalf of NPATA, for respondent number 4. Today said we have filed our Bakalatana, so we need some more time to file the affidavit in opposition.
Service of notices given to all the respondents. They release this matter for admission in the week commencing from 29th of July. In the meanwhile, the respondents will file their affidavits, if any, on or
Lordship,
before,
I'm for respondent number 1 and 2. I need time for filing affidavit.
on or before 25th of July. Okay. Yes, next.
May I please, Your Lordship? Your Lordship, I beg to mention number 37 on behalf of T. Tagum, Learned Standing Counsel for Health Department. I have taken consent from the other side. Due to health issue, we could not appear today. This is
The week commencing from 29th.
matter we fix after vacation.
Yes.
May I please? My lord, with consent from other side, my lord, I beg to mention item number 6, man.
Yes,
I am on behalf of Mr. D. Pangin, for
Hmm.
respondent. ma'am.
yes, what's your prayer?
My matter may be adjourned today, man.
Week commencing from 22nd. For admission, okay.
Obliged.
Number 30. Hello, please. This is a case pertaining to the continuation of departmental inquiry after retirement. Now, I am here, I am challenging the page 60, that is the order.
When did you retire from service?
Yes, I have retired
When?
on 31st May. I have retired from service on 31st May. That is released in page 59.
Okay,
Sri Inyo Nankar, former Director of Land Management Department, Government of Arunachal Pradesh, Itanagar, is hereby released from the government service with effect from 31st May 2024 AM.
where is the order? First,
Oh, there is annexure 12, page 59, is the release order from the service. Now, again, they have passed the order on 6/6/2024. That is annexure 13, page 60. Here, the CEO, sales officer, is directed to submit his written brief to the inquiry officer within 28 June 2024. If no written brief is received by the inquiry officer within 28 June 2024, it will be presumed that he has no written brief to submit, and the inquiry officer will finalize the inquiry report for submission to the DA. Now, once I have been relinquished from the job,
the departmental proceeding initiated prior while you were in service.
the initial appointment inquiry officer was in. First appointment was made
No,
on
no,
page
just tell
49.
Just tell us, Mr. Patil, whether the departmental proceeding initiated while you were in service,
Departmental, it was in the year
2022.
21.
Okay, But during your service period, the
It-
inquiry did not,
It
was
was
not complete.
continued. It was continued. And Ajay Kumar Biggs, IS secretary, was the inquiry officer. Then, since he was being transferred out, another person was appointed. That is dated Itanagar 4th September 2023. That page 15, page 50. Longpai was appointed as the inquiry officer here in the case. Now, from the date of appointment, what law says? Law says that inquiry should be completed within 6 months. Within 6 months. So when he was appointed on 4th September 2022, then within 6 months, the inquiry should be completed. In case the inquiry is not completed within 6 months, he should seek in writing, seeking the extension of the inquiry from the competent authority. But here in the case, after appointment from 4th September 2023, the time has already been 6 months has already been expired, and no further extension order was passed. And
Yes,
now,
is appearing, you are appearing? Okay, we'll just at this moment, we'll issue notice.
Close.
Nothing else, because there are large number of decisions. What we could see that page 57, even before his retirement, the proceeding was going on. And there's a letter, the date was fixed on 28th May, but the petitioner took time. Anyway. Pardon, Mr.
my lord,
But in the senior counsel,
this order may be suspended.
you were assisted by Mr. Davi?
Yes.
Okay. For the petitioner. Also heard Mr. Terry Leonard. Stanley, you are government advocate?
Close.
Here you are appearing for tourism department.
One and only one lordship. Two lordship, standing counsel is there, Lord.
Why you have made the enquiry officer a party?
Huh?
Enquiry officer you made a party. The disciplinary authority is already there.
Huh?
Anyway,
Inquiry
is there
officer-
land management department?
Mr. Kamdukos.
But he's on leave. We have served him copy, but he's on leave.
After your suspension, whether you have been reinstated in service?
Yes,
At the time of retirement, you were serving as what? At the time of retirement, you served as what?
I attach you, secretary.
As an officer in the tourism department or in land management department?
No. Special officer, no? No, no designation was given. But entirety of official, all the facilities of official park was here enjoyed. Vehicle was given, driver was given, petrol was given.
Where is your reinstatement order?
Huh?
Have you annexed?
4. The page 40,
Page 14.
page 40.
40 is your reinstatement order.
Yes. Page 41, and according on revocation of his suspension, Sri Enyo Nangka, Director of Land Management, shall report to the Office of Chief Secretary, Go of Onasal Forest, Itanawa. So accordingly, we comply this order.
While serving as Director of Land Management, a disciplinary proceeding was initiated against the petitioner by a memorandum of charge dated 04/02/2022. Though he was suspended from service by order dated 30/09/2021, being detained in custody for more than 48 hours with a vigilance PS case. Later, by order dated 30/06/2022, he was reinstated in service. The petitioner, on attaining the age of superannuation on 31/05/2024, was released from service petitioner is aggrieved as the Secretary Home, the concerned inquiry officer, by communication dated 06/06/2024, directed him to submit his written brief on or before 28/06/2024 in the said disciplinary proceeding. Even after his retirement from service, the petitioner has filed a said petition. Issue notice returnable by (24th). As Mr. Such and such accepted notice on behalf of the respondent number 1. No formal notice be issued. Please say respondent. However, petitioners shall requisite extra copies to such and such by tomorrow, date Friday, obtaining necessary acknowledgement in that regard. Put the date tomorrow. Sir. Petitioner shall also serve requisite extra copies to Mr. Kamduk, outstanding counsel land management department for the respondent number 2, obtaining necessary acknowledgement him from in that regard. Petitioner shall take steps for service of notice on the respondent number 3 by registered post with AD by tomorrow, providing its correct and proper address with regular postal stamps. Petitioner is also allowed to take steps on the respondent number 3 by justiciable personnel service to be routed to the registry of this court. Such justiciable personnel service shall be made on the respondent number 3 by serving him a copy of this petition, including the annexes of the approach, obtaining its ITS signature with date and seal in presence of one or more witnesses. Thereafter, petitioner shall submit an affidavit towards completion of dusty service on the respondent number 3. Such dusty service on the respondent number 3 shall be made on or before 16th July. The interim priority petitioner shall be considered on the returnable date after due service of notice on the respondents.
No. Then that means the 28th June is the last date.
Yes, the arrangements of the apex court. That's why you are not saying anything. It will be considered on the next date.
Yes, ma'am.
Yes, Mr.
Yeah, please, your Lordship.
Yes, Mr. Raff.
At the first place, Lordship, I'm sorry because because of this computer tricks, some words have been amalgamated. I'm sorry for that, Lordship. So, Lordship, here is a case of selection of teacher, assistant professor.
Lordship, before, I'm appearing on behalf of T. Tagum, standing counsel for health and
Education Department, yes.
health.
Health, okay.
He could not come today. The matter is listed for motion. May I pray that the matter may be listed tomorrow?
I have no problem, but if they make appointment tomorrow, Lordship, that may be taken care of, Lordship.
Tomorrow, yeah.
At least for 2-3 days, appointments may not be there, Lordship.
Anyway, place your case. Let us see.
Lordship. May I take your Lordship to page 25, Lordship?
Yes.
This is the Gazette notification. National Medical Commission, Postgraduate Medical Education Board, notification, New Delhi, Port.
Which is the relevant provision?
Lordship.
Which is the relevant provision for?
Yes, 3.3, Lordship.
3.3.
3.3. In the Department of Anatomy, Physiology and Biochemistry, Lordship, we are concerned with biochemistry. Non-medical graduates having MSc, relevant medical, N, the word N is there, Lordship.
You are.
I'm medical, and the private respondent is non-medical, Lordship. So this is for private respondent, Lordship. Now, and PhD qualification.
Non-medical graduates having MSc, relevant medical and PhD qualification, yes?
Yes, Lordship. Both these two must be there, Lordship. N is conjoined, Lordship.
Yes.
Lordship. So this is mandatory. Now, Lordship, then many advertisements were there. On 3 occasions, they tried to get the eligibility criteria.
Yes, then what happened?
Lordship, then page 29, Lordship. Next slide.
What is the advertisement?
Yes, page 22, Lordship.
Page? Advertisement.
Latest one is, Lordship, page 39, Lordship.
Page 39.
Yes, Lordship. Interview for filling up of following posts will be held on 15/4/2024 at 10 a.m. onwards in the office chamber of the Director TIMS, that is Tomoreva Institute of Health and Medical Sciences, Naharlagan.
Now, the post relates to anatomy.
Yes, the biochemistry, Lordship, serial number 3.
Serial number 3, biochemistry.
Yes, one post regular.
Hmm.
Then, Lordship, then terms and conditions, Lordship.
Yes.
Eligibility criteria as per NMC. One, National Medical Council
Hmm.
and Commission Lordship. This is what at given at page 25.
Hmm. Okay.
So as per this, she is not eligible, but she has been selected, Lordship.
Where is that?
Selection is page 56, Lordship.
Her name is there.
At serial number 3, Lordship. Biochemistry, Assistant Professor E. Shruti, Dr. E. Shruti, selected.
But she is MSc in biochemistry and PhD.
No, Lordship. This is what we are challenging. If she is PhD, I have no case.
Yes.
Then that's why, Lordship.
She is not a PhD holder.
Yes. She is not a PhD holder as per our information. As per our
Page
information.
number 49.
Yes. Page number 48 is also there, Lordship.
No, her name-
Sorry, page number 49, Lordship.
This is
Yes.
for the post of biochemistry.
Yes, Lordship. E. Shruti, MSc Biochemistry, PhD. This is given here. 2010 MSc Biochemistry and PhD Medical Biochemistry in 2023. This is given. This is what we're disputing. Then, Lordship, in page 50, details of result, Assistant Professor Biochemistry, no candidate has been selected for the post. Then so we have made a categorical statement that she has not obtained PhD degree. If she is having PhD degree, we have no case. We have no case. Yes, there's another point. Because one of the selection member, scrutiny board member, is her husband. That we have made
only in the member, not in the selection committee, but as a member in the while there is a member in the scrutiny committee.
Yes.
That will not hamper. Scrutinizing documents possible, but should not be a member of the selection committee.
Lordship. Now, Lordship, my limited prayer would be, Lordship,
Okay.
let notice be issued and let it be the outcome of her appointment be outcome of this writ petition if she has not already been appointed today. But as per Lordship, RTI is still pursuing PhD, not consultative.
Where is the selection?
Page 56 only, Lordship. In respect of many were selected, Lordship. We are concerned with serial number 3, Lordship, biochemistry. We are not challenging the whole process, Lordship.
Okay. Pardon, Mr. Razinappa, Granted Senior Counsel, assisted by put her name counsel for the petition. Matter relates to selection and appointment of the respondent number 3 as election for a post of is it assistant professor? Is it assistant professor? Assistant professor of biochemistry. In Tomo Riba Institute of Health and Medical Sciences, within bracket Dreams, Government of Arunachal Pradesh. Advertised on 15/03/2024. In the said advertisement issued by the Director Dreams, it was specifically mentioned that the eligibility criteria for such post of assistant professor shall be as prescribed in the National, as prescribed by the National Medical Commission. Mr. Rapang, Radha Senior Counsel appearing for the petitioner. Before that, it right. Petitioner being eligible also participated in the said selection process for the post of assistant professor in biochemistry in Dreams pursuant to the said advertisement dated such and such. As per teachers' eligibility qualifications in medical institutions, regulations 2022 of the National Medical Commission within bracket Postgraduate Medical Education Board issued on 14/02/2022, also published in the Gazette of India, Extraordinary Part 3, Section 4 on 22/02/2022. Norms for appointment of faculty in medical institutions relating to biochemistry as specified at clause 3.3 is page number 25. It's marked there. It is submitted by the petitioner that though the response number 3 doesn't have the requisite eligibility as been prescribed by the NMC in its notification dated 14/02/2022, published in the Gazette of India on 22/02/2022. The respondent authorities in the health department selected her for appointment to the post of assistant professor in Dreams, Naharlagun. And in that regard, the director, the Secretary Health and Family Welfare Department, Chairman of the Executive Council to himself, notified the results on 20/06/2024. Mr. Apang Leonard, Senior Counsel appearing for the petitioner. By placing the communication dated 16/06/2024 of the petitioner. You can send representation. Submitted before the Health Minister of the state. That the respondent number 3 is only a master degree holder, Master of Science degree holder in biochemistry. And she doesn't possess the PhD in medical biochemistry. Has been granted by any recognized medical college / institute as a regular on campus course as required in terms of the NMC regulation 2022. Law is well settled that if at the time of filing of any such application pursuant to an advertisement, a candidate does have the requisite eligibility, the said candidate cannot be selected for the post advertised. Mr. T. Tagum, Standing Counsel, Health and Family Welfare Department of the state, is absent today by filing leave note. Is it there? His name is there?
No,
No, okay. He is absent today. Mr. Rapang, Leonard, Senior Counsel. Submitted that the respondent authorities may appoint the respondent number 3 in the post of Assistant of Professor of Biochemistry at NICAMS at any point of time, as results have been already declared on 20/06/2024 for the said post. Issue notice returnable by July 18th. Petitioner shall serve requisite extra copies for the respondent number 1 and 2 of this allowed annexes appended to Mr. T. Tagum Standing Council, Health and Familial Department. Tagum will appear for 1 and 2 or
One and
both? So one corresponding numbers 1 and 2. By tomorrow, obtain necessary acknowledgement from him. Petitioner shall also take steps on the respondent number 3 by registered post OTD, providing her correct and proper addresses with the requisite postal stamps, such and such. Tomorrow. In the interim, it is made clear that the respondent numbers 1 and 2 shall not appoint any such candidate, including the respondent number 3, as assistant professor of biochemistry in Toborima Institute of Health and Medical Sciences, Nahal, in violation of the recruitment rules has been prescribed by the National Medical Commission in its notification dated 14/02/2022, published in the Gazette of India on 22/02/2022, as noted above in paragraph such and such. Okay. List according.
Lordship, may I pray, since there is interim, shorter.
Interim is what? We have said anybody who doesn't fulfill the requisite criteria shall not be appointed. That's all.
Very pleased, Lordship. But I have filed this application under 226. Well, the thing is, this the petitioner is a contractor. And the government issued a e-tender notice for construction of playground with RCC gallery at Korea. And there were 4 bidders, and I am the L1. I was selected for the construction work, and I completed all formalities. Thereafter, my lord,
Now, please tell us when the NIT was issued.
NIT was issued, page 18 or Lordship C. It is on the official website.
On which date?
Date was not there, madam. Date of opening tender was there, 27/3/2024. Time 10:30.
What was the last date?
27/3/2024. Last date for submission.
When the model code of conduct came into force?
That
Mr. Tapin will be, when the model code of conduct came into force?
16/3/2024.
March.
16th of March.
16th of March.
This NIT was issued on 20 something like that. Mr. Sharma, come to page number 19.
Yes.
Period of downloading the bidding document was from 28th of March
Yes.
to 27th. Date of time of submission of bid was also from 28th of March.
My lord, I am not disputing this, my lord. The whole thing is this, the executive engineer started the process, evaluation, everything was done and I was selected as L1. Thereafter,
Where is the order? Where is the order by which?
order is your page 24 onwards. Your
Hmm.
Lordship.
By which
Annexure
the-
5.
this entire process of NIT has been cancelled? Where is that order?
Impugn order is at page 29.
29.
The the inviting tender so and so, this order is being issued the following MCC rule under ECI.
It was issued in May. We are end of June, Mr. Sharma.
Page 30 or what you can see. This is the letter. This is the letter by the ADC to the executive engineer. ADC is the returning officer, the district election officer. He wrote a letter to the executive engineer.
Where is that letter?
Page 30. Here the returning officer asks the executive engineer, second paragraph, on the last line, your lordship can see, MCC guideline and the NIT be kept in abeyance till lifting of model code of conduct. Therefore, case is this, my lord. The learned and the executive engineer, instead of keeping the entire process in abeyance, he cancelled the entire process. Moreover, my lord, if your lordship kindly look to paragraph, page 30.
Heard Mr. Yasirmal and senior counsel assisted by Mr. Counsel for the petitioner.
Lordship,
You are appearing for all the respondents?
on up to 7 lordship. 1 to 7 lordship. 1 to 7.
Mr.
Here lordship,
Kuchar.
a small objection on mandability lordship. Here the bidder is not before us lordship. Bidder is one lordship MS
Proprietor of Messrs. Atuapa Developers.
lordship.
So,
So Sangataji, he entity is different lordship. Bidder lordship, Atuapa, MS Atuapa lordship, he is the bidder lordship. He is supposed to be before this court lordship.
who is the proprietor?
Proprietor lordship, his entity is different lordship, maybe lordship. To my understanding lordship,
The farm is no entity, the person is
the award is not lordship supposed to be lordship made to the petitioner, present petitioner, but to MS Atuapa
If it
enterprise.
is a sole proprietor, then
Lordship, this is a registered contractor lordship.
registered contractor
MS,
may be-
not in the name of Sangatajik lordship, in the name of MS Atuapa enterprises lordship. Once it has been registered lordship, and NIT bidder was invited from the registered contractor, not as Sangatajik lordship. And MS Atuapa is the lordship registered contractor lordship.
Page 16 of lordship, see, annexure 1. Sole proprietorial farm. Apu, Apa developers.
There's no dispute that is a proprietor lordship. But proprietor and lordship, the firm, these are the two.
No. Proprietary, they are not too different.
The
Farm
entity-
is represented by the
Their
proprietor.
entity is completely different from
No,
each
no,
other.
farm is represented
there
by
is
the
a
proprietor.
judgment clears.
Yes, a judge lordship.
You just see, authorization will not do. If somebody authorized to
Lordship.
appear, that can.
Law is
be-
very clear on this, so citation is not with me right now, lordship.
Okay. The executive engineer. Sangram PWC division. Wide number SGMD oblique NIT oblique KLG oblique 2023-24 oblique 01 dated nil is dated nil issued NIT then e-tender for construction of playground within RCC gallery, which RCC gallery?
Yes. Polarium.
Of Vivekananda Kendriya Vidyalaya, Polarium. With the specification that with the, for an estimated amount of rupees 1,48,05,030 to be completed within 6 months. Specifying further that period of downloading the bidding document dash 20/03/2024 to 27/03/2024 up to 10-20 hours. Roman 2, first will be Roman 1, Roman 2. Start date and time of submission of bid 20/03/2024 from 0900 hours onwards. Last date and time of submission of bid 27/03/2024 up to 10-20 hours. Date and time of opening of bid 27/03/2024, time 10:30 hours. In the camp office of Executive Engineer Sangram Division, PWD, Jolang, JOL Lanes, Itanagar. Petitioner along with other bidders participated in the same process.
My death notice was also some extended annexure 4.
It was extended.
Extended. Annexure 4, page 23.
Before that, is right. By tender notice, the executive engineer, Sangram Division PWD, on 02/04/2024, extended the opening time of the bid documents up to which day?
8/4.
Up to
Consequently, the phrase did
8/4/2024 at 15 hours. By the concerned board, after selecting the bid documents, by its decision dated 09/04/2024, considered the petitioner's proprietary firm Messrs. Atu Upper Developers as L1 bidders for the work notified in the NIT noted above. Some complainants approached the district election officer Colorium with regard to the said NIT involved in this case.
My lord, that is that
Pursuant to the same, the district election officer Colorium on 09/05/2024 wrote to the executive engineer Sangram PWD division intimating him that the NIT issued by him with regard to issued by him was processed during the Model Code of Conduct of the election, parliamentary and legislative election 2024. Which is in contravention of the Election Commission of India's guideline on Model Code of Conduct. And accordingly, asked him, directed him to adhere the Model Code of Conduct guidelines, and the said NIT should be kept in abeyance till lifting of Model Code of Conduct. Model Code of Conduct. But the executive engineer, by its order, office order dated executive engineer Sangram Division PWD dated 22/05/2024. On receipt of said letter from the district election officer Colorium dated 09/05/2024. Work order was issued to you? No, I don't think so.
not issued. Because cancellation of the my tender, my NIT.
Cancelled the NIT. Put the number we have initially. For the works under the PWD Colorium subdivision, Kurumkume district, floated during the operation of Model Code of Conduct, instead of keeping the process in abeyance, has been directed by the district election officer Colorium. Hence this said petition. Mr. Tapin Learned Counsel appearing for the official respondents number 1 to 6, however, raised the issue of maintainability as the petitioner is not the bidder concerned, i.e. Mrs. R2 upper developers. And he as a proprietor could not have filed this writ petition. Issue notice returnable by 3 weeks or 4 weeks. as Mr. Tapin has mentioned, accept notice on behalf of no formal notice, serve requisite extra copies within 2 days from today. Petitioner shall take steps for service of notice under response number 8 to 10 by registered post within 2 days, bring the correct and proper address to registered post. The order of cancellation of the NIT number such and such issued by the executive engineer Sangram such and such shall be subject to the outcome of this writ petition. Maintainability of this petition shall be considered at the time of its admission stage. Let's take note.
Interim,
Until or just
interim prayer, my lord, page 14.
without
Well, there are some foul play. The executive engineer may float new tender to get the his interested person to get the
okay.
work.
Look,
Therefore,
without the leave of the court, the respondent authorities, including the executive engineer, respondent authorities in the public works department, including the executive engineer, Sangram Division, Public Works Department, Sangram, Arunachal Pradesh, shall not issue any fresh tender pertaining to the construction works of the playground with
playground
RCC
with
gallery
RCC gallery.
in the VKV Colorium.
Lordship,
Eleven.
my objection on maintainability, that may
The
be
admission stage,
on next, it may be reflected
admission stage.
in admissions. Okay.
Replay.
Item number 1.
I'm for the
Just a minute,
department.
just a minute. Who is for the state? Who is for the state? What is the procedure for regularizing any contingency employees? Okay, you are the
Yes,
horticulture.
yes, Lordship.
How you regularize any persons appointed in
We have
contingency?
to go to the recruitment rules of the department, Lordship.
No, that's it what I'm asking you. What is the procedure for regularizing the service of any contingency peon in the Department of Horticulture?
Lordship, I'm really sorry. I have just been appointed and just got the copy, Lordship.
Do you have the rule with you? What is the recruitment rules?
Reply. Lordship, I don't have the rules also, Lordship, with me. Yes, sir.
Worship method for recruitment, according to recruitment rules. By promotion on the basis of seniority, subject to fitness from among persons who have rendered not less than 5 years continuous service in the grade of peon from the establishment where the vacancy have occurred. The recruitment shall be made subject to reservation for scheduled caste and scheduled tribe as specified in the Government of India's instruction regarding reservation in post of filled up by promotion on the basis of seniority subject to fitness issued from time to time.
None appeared for the petitioner and call when the matter was taken up for consideration. Heard such and such and such. Matter is pending since 2017. Heard such and such and such. List on. Listen the week commencing from. Twenty-ninth. Yes, next. 29, this month. Okay. Yes.
Lordship, the petitioners are in 27 in number, Lordship. Okay. Here in this case, Lordship, the petitioner, Lordship, in the year, Lordship, 1986, Lordship, 1996, Lordships, applied land allotments for the vacant land within the Alo Township, Lordship. Lordship, which was not considered. Having no option, Lordships, submitted the representations before the Honorable Chief Minister's Minister Land Management's Arunachal Pradesh, Lordship, for allotments of residential plot at Koi Hisam at Alo, Lordship, annexure, Lordship, 2, Lordship. Application is submitted, Lordship. And to the effect, Lordship, you are not page, Lordship, 24, Lordship. To that effect, Lordship, annexure 2 series, Lordship, page 25, Lordship, your note is issued, Lordship, to consider and look after the case of the petitioner, Lordships, directing the DC to consider, Lordships, before the next DLAP meeting for the consideration, Lordships, annexure 25, Lordships. Accordingly, Lordships.
Yes, so Mr. Tay, you have filed an affidavit.
Yes, Lordship.
Was there any excess occupation of land by BRTF?
Lordship, this land they are claiming is already allotted to the what is this?
BRTF.
BRTF already, Lordship.
No, whether the BRTF is in occupation more area of land than allotted.
Lordship, I have annexed the cross verification order also where all the finished petitioners were also present. Annexure A, page 10, Lordship.
Where is your affidavit? It's not here.
My affidavit
Lordship.
by Lordship.
Page 10, Lordship.
3 and 4.
That is what we are trying to get it. It's not available. Your writ petition is up to page number?
In my writ petition, Lordship. My writ petition, Lordship, page 182, Lordship, page, Lordship.
There is no affidavit in opposition, but there is an affidavit in replies there of the petitioners.
Lordship, government affidavit is there.
There is another affidavit.
Lordship, we have filed.
It's not available here.
22 itself, Lordship.
In a separate,
February
separate
22.
file. Yeah. Okay, okay. What is your stand?
Lordship will see my stand here at the Lordship, the verification is here, but in the state.
Joint survey was made.
Yes, Lordship.
Then
Cross verification, Lordship. Here, Lordship.
where is the report?
Report, Lordship, in annexures of government affidavit, Lordship, page 10, Lordship. Page 10, Lordship.
They were also present, Lordship, here.
Yes, Lordship, we are present, Lordship.
Page 10, para.
Para, Lordship, main, Lordship, first, Lordship, page 10, annexure A series. Lordship, finding of the case 11, Lordship. Finding of the case, Lordship.
Affidavit of whom?
Affidavit of government, Lordship.
Lordship.
Respondent number 3 and 4, Lord. Yes, 3 and 4, Lordship. 3, Lordship.
Lordship, in 3, Lordship will see the land allotment documents submitted by the DRT reveals, Lordship got it? Reveals that they are allotted land in plot number 1 and 2, measuring a total area 1,43,683 square meter in plot number 1, and plot measuring 25,875 in plot number 2, Lordship. And the petitioner's claiming plot is in plot number 1 of the Lordship, DRTF, Lordship. Lordship will see here. Lordship, all of this finding have to be read, Lordship. Page 12, Lordship. Page 12, next page, Lordship. Breakup of physical findings during cross verification of land is as given below. Page 12. Here difference is only 1,000 square meter in excess, and that also, Lordship, they have explained that the measurement of land is done by using 50-meter tape manually. Hence, error within 5% limit is considered. 5% of
Now just tell us when the land allotment was given to the BRTF.
BRTF 1989, Lordship.
Okay. When did they take possession?
Possession of the land, Lordship will see in my affidavit.
And
itself.
with regard to the petitioner's allotment was made when?
Lordship, 2013, Lordship.
2013, Lordship. This is 89, and Lordship, compensation has also been paid. Lordship will see in my page 44. At that point of time, 7,18,000 Lordship were given, paid to the Lordship, administration. Lordship. This is a double allotment. So, Lordship, the authority is cancelling the allotments. Lordship, is
Already cancelled or yet to be cancelled?
yet to be cancelled, Lordship. They have
Lordship,
issued-
cancellation order
has been issued, but Lordship.
but
is-
approved by the authority, Lordship.
Yes, Lordship.
Cancellation
Since
has
it's
been,
already under the possession of the,
Lordship, my claim is, Lordship, only, Lordship, here, Lordship, in paragraph 9 of their finding, Lordship. Finding, Lordship, what they are saying, Lordship. May I read, Lordship, paragraph 9, Lordship.
Lordship, allotment is in 88 to BRO. Lordship, in my page 18, sorry.
you have been allotted land at
In
1 or 2?
Lordship,
Plot number 1 or plot number 2?
Lordship,
Plot number
as per
1.
their plot number 1, Lordship. Plot number 1, vacant land, Lordship, excess land, Lordship. They are not saying, Lordship, this allotment is given to BRT, Lordship. But Lordship, here is direct
Your land relates to plot number 1 or plot number 2?
plot number 1, Lordship.
And in the plot number 1, they have been found that they are in occupation of,
BRTF lordship.
BRTF is in occupation of only,
There, and lordship observation, may I read lordship, in observation lordship,
Hmm.
there is no any documents with the government lordship.
Hmm.
This case is wholly based and finding of this impugn order is lordship on the basis of the documents provided by the BRTF and lordship petitioner lordship.
see, Mr. Counsel, the land was allotted to the BRTF,
Yes, lordship.
file number something dated 29th of January 1988.
Yes. Lordship, my.
And the land was handed over to them
Yes.
on 28th of September 1989. Your land, you have been allotted land sometimes in the year January 2013.
Yes, lordship.
So they are already in occupation of that land,
Yes, lordship.
right?
But on recommendation lordship,
No, because there may be some land may be vacant,
yes, lordship.
but earlier the land was already allotted to the BRTF.
Yes, sir. That is our
So
stand.
what
Lordship.
remains?
On the recommendations of Deputy Commissioner lordships, page 26 lordship. Page 26 of my read petition lordship.
Yes,
Uh,
page 26 of what?
Page 26 lordship,
Huh.
in except 3.
Your repetition.
Yes, lordship.
And now when did the committee was constituted as per the law?
Committee lordship,
Earlier, who was eligible to allot the land?
land lordship, and during that lordship was Dalap.
Who had
Committee
the eligibility, who had was empowered to issue allotment order?
allotment order lordship, it's the district administration lordship.
Who is the head of the district administration?
Yes, lordship.
Recommending authority.
Yes,
but
this is
then-
recommending authority lordship.
Hmm.
On the basis of their recommendation lordship, there is also the approval letter lordship. My land allotments order is approved by the land department lordship, which is at page number lordship 29 lordship. Page number 29 lordship. This is approval which is communicated by the Director of Land Management to the Deputy Commissioners, West Siang District.
Where is the
Lordship.
recommendation?
Recommendations, lordship, recommendation is at annexure lordship, page number 26 lordship. Page number 26 is recommendation lordship. Recommended by the Deputy Commissioners, which communicated to the Director of Land Management, Governments of Arunachal Pradesh lordship, for allotment lordship. May I read lordship?
Yes, please.
Some paragraph 1, 2, 3. Just 1, 2, 3 lordship. In paragraph 3 lordship, for the body lordship. In this regard, I am to inform you that the proposed residential plot is presently under excess occupations of BRTF, which is openly swimpy land and surrounded by few temporary structures, photograph enclosed for ready reference. On the basis of this lordship, this allotment is recommended by the Deputy Commissioners on the excess land occupied by the BRTF lordship. Here is the case lordship. Directions was given to cross-verify the excess land. Though the department lordship, district administrations lordships, only cross-verify the plot number 1 only lordships. If lordship,
Now, just tell us one thing.
and if lordship,
Just tell us one thing.
yes, lordship.
This is the access line of BRTF,
Yes, lordship.
where from the deputy commissioner came to know. Was there any verification prior to making this statement by the deputy commissioner?
Lordship, I have that much only documents available with me, lordship. Documents which
Yes,
was here,
Madam
lordship.
Ate, this letter, page 26.
2012. We have
Do you have the relevant file of the deputy commissioner? This LM/WS-03,
yes, okay.
that is the relevant file. Where from the
Lordship, error has been made, Lordship, mistake. We have accepted that there has been a mistake, but then Lordship, finally it has been found that this comes under the.
just tell us one
operation
thing,
of-
just tell us one more thing. Page number 26 of the writ petition.
Yes, sir.
Copy two. Copy two. What is the necessity?
This was way back in 2012.
What is the necessity? That is the reason.
Not at all.
That is the reason. Had it been written to land management department or the somebody in the
Yes,
looking
sir.
after, that is could have been different.
This could be Secretary Land Management copy two
Who?
at the most.
But why the PPS to the ministers
Yes, Lordship.
has no relation with the land management or revenue? That itself indicates something fishy.
Lordship, but then my page 14, Lordship. This is the Honorable Court's order to cross-verify the land. So accordingly, this cross-verification was taken place, Lordship.
My
In
simple
my
prayer,
page 14, Lordship.
my prayer is simple prayer is Lordship. Kindly Lordship direct to the authority concerned to verify the plot number 2, Lordship. If there is an
You have
excess
no right to
land-
do after verify that. You are no
Clearly
longer,
say it's-
you are not in, your allotment is in post number 1.
Yes, we have clearly said it's in plot number 1. We can, Lordship.
Dismiss.
Yes.
That's the finding.
Much obliged.